sleep to move two very unlisted urgent motion. Your Lordship, kindly give me leave. I shall file it today. I shall serve. Your Lordship, kindly take this matter. Both are of the Group 7 matters. Your Lordship, kindly take the matter.
What is your urgency?
Urgency is this: Your Lordship was pleased to set aside the assessment of tax and send the matter before the Chief Secretary, Principal Secretary, for reassessment of the thing. In the meantime, the car has been seized for non-payment of tax. What shall I pay? No assessment is there. Your Lordship will set aside both the assessments and send the matter. Matter is pending before them. They did not consider one in the month of December, another in the month of March. Both has not yet been considered.
Please file the matter and give the number, and it will be.
Unless
It will appear.
keep the leave, it will not be taken up in the department because 48 hours is not there.
Day after tomorrow is 48 hours.
Department will not take.
Department will
say
not take.
you have to give a date after.
Department will say that date will be
48 hours is day after tomorrow.
I know, but the department will say 48 hours count from today itself.
No.
Today 24, tomorrow 24. And Monday it will be listed.
I'm suffering for that. 48 hours means it will be counted from tomorrow. Tomorrow, day after tomorrow, so we are after vacation.
After vacation.
They are
So, whatever you
Give the.
I shall
No,
file
Lord.
it, make it.
Yesterday your
let it be taken up on Friday at the top. Otherwise, I shall get sued.
My Lord, your Lordship granted me the leave, my Lord. I could not hand over the number yesterday. My Lord, right
Please
now,
give the number.
yes.
Lordship's kind leave. I'm praying for leave to file and move day after tomorrow, short service. Urgency is that, my Lord, the Honorable Division Bench directed the authorities to consider 10-3 proceedings. Number 10-3 proceedings, I have attended in the hearing. There is no order in 10-3. I have a statutory appeal in 10-4, but even before that, the police is coming and saying that we will demolish. Therefore, I'll be praying for protection, my Lord, only to that effect that no coercive steps be taken before 10-3 and 10-4 can be done.
Give the number.
After
Yes.
tomorrow,
Yeah, have your Lordship's leave to mention one listed matter? There's
Right.
item number 122. And,
Item number 122.
122.
Yes.
I'm praying that the matter be listed as a specially fixed matter tomorrow for hearing. It's
What is
very
your
urgent
urgency?
matter
What is your urgency?
because the petitioners are literally on the road because their road entrance is obstructed by the erecting shops by the private respondents. And they're
That is not very urgent, madam. Please wait. Please wait for your turn. I'll take it up. It's running in the supplementary list.
My Lord,
It's in this daily list.
still list.
I'll take it up.
Your Lordship, I have mentioned this matter on Monday, Your Lordship, and Mr. Farooq Radar has mentioned this matter, seeking leave to file this application, Your Lordship, and matter was, Your Lordship, for that we should file the matter and supply the number. We have supplied, Your Lordship, but as the department did not accept it, the 48 hours notice as on today, so the matter is, they have taken it on 18th, Your Lordship. In the meantime, Your Lordship, on Friday, HDO has come up and closed my shop.
18th is tomorrow.
Tomorrow, Your Lordship. Tomorrow, second half, Your Lordship, original matter will be taken. This is we attend, Your Lordship. The shop is closed.
Tomorrow, second half, original side matters are taken up. So it will be taken up day after. It's a group 7 matter.
Yes, Your Lordship, with regard to the registration of e-vehicles.
It will be taken up day after tomorrow.
Your Lordship.
Day after tomorrow.
Can it be given some precedence, Your Lordship?
Day after tomorrow, closing day, very little
Lordship,
matters will be there.
The shop is closed, Your Lordship. We mentioned this matter for urgent.
I'll see. Yes.
189 of this, the matter is very urgent. Sir has been permitted to query this land, but just now after passing on Lordship, listed order, they have directed not to operate the inquiry. There is an injunction,
Give the number, let me see.
My Lord,
189.
item number 113 of
You have to give a slip.
my Lord, item number 113 of today's list. Last day it was appeared at item number 84. My senior mentioned before your Lordship, as service was not made, that's why it was not allowed. Last day I served upon the state respondent, learned advocate. He received the same
When is
today.
it appearing? What is the date?
My Lord,
When is the matter appearing next?
my Lord, what happened, my Lord? On 12th April, it was appeared before your Lordship. After hearing the matter, your lordship directed it will appear on 11th May. 11th May it was appeared, but my lord, what happened day after date? It is going back. Now today it is 113. Urgency is my lord.
11th May, some date was fixed. What is the date fixed?
My lord, date was fixed on 11th May.
After that,
After that, minor 11 day, it was listed, but it was not reached before your lordship. What happened, my lord? Day after day, it is going back. My lord, urgency is sand was stopped in the year of 2020-22. It is being damaged. It should be disposed of immediately, my lord. Analogous matter, which was filed in the last month, that was listed before your lordship's court last Friday, after my petition. But my lord, without I was made private respondent in the said 10 matters, my lord. But my lord, what happened? No notice was served upon me. I don't know whether it was mentioned or not. But last Monday, that was updated as item number 19 to 28, and the same was disposed of. Now, same urgency in this case also.
give the number, let me see.
I'll kindly take it on tomorrow or day after tomorrow,
The
my
number, there are 2 more days left, let me see.
lord.
My lord, may I have
Yes.
lordship's kindly to mention item number 140 of today's list. There is the urgency. my
What
lord.
is your urgency?
Urgency is this, my lord, in absence of the mutation, my Salt Lake property, the petitioner has been suffering. But they
This
have
is
not
not very
considered,
urgent, you can wait.
kindly consider, they have not considered the application for
I
mutation.
understand. but
Only
this
they
is
have
not,
not kindly dispose of the
not
application,
imminently
my kindly direct them to consider
yes,
there.
it is in the supplementary list, please.
Yes,
wait.
my
It will
lord,
be
that's
taken.
why,
Please
my lord,
wait, it will be taken. No, updation is not
If it is
required.
not reached today,
Upgradation is not required in this matter, sir. It's
But
not that
kindly
urgent. It can wait till the
let
vacation.
it appear on Friday or
No, 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 not at all.
some
It- no,
precedence.
no, Not at all, not at all. It will wait, it can wait till the vacation. Yes, call the days list, please.
Item 1.
My lord, I'm appearing for the petitioner, my lord.
Yes, appearing for the first time,
Yes, my lord.
so please serve and come.
Yes, my lord, the impugn order is at page 90.
Please serve and come back. Contempt
Diploma.
service. 20th June. Two zero.
Item 2.
I am for the Alex contempt of lordship.
I am for the petitioner.
Report is ready and
Compliant?
compliant with lordship, hearing was given and several times. And focus notice was issued and on the last occasion, lordship, warrant of arrest has been issued. Just fill the back. Only the interest party is due.
Yes, madam, what do you say? Have you seen the report?
No, my lord.
Do you want to go through this and come back?
Yes, ma'am.
Yes, if they want to, they find the exception.
Yes?
Let the matter may be fixed.
My
Will you
lord,
deal with it here and now or you want to come back?
I'll come back, my lord.
You'll come back? Very well. Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph, copy of the affidavit is served upon learned counsel for the applicant petitioner in court this day. Paragraph, on prayer of the applicant, the matter is adjourned. Let the matter appear under the same heading on 21st June.
My lord. Item 3.
Lord, item C, my lord, this is the first time.
Please serve and come back. 21st June.
Grateful.
Rajiv, 21st June returnable. Three. Service direction.
Item 4.
I'm the content applicant, my lord. They have filed the everything in opposition just yesterday. I need some time to reply and for hearing.
You want to use an exception?
I am for the petition, writ petition and
Want to use an exception to the affidavit?
yes, my lord, yes.
Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, learned counsel for the applicant petitioner seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on 22nd June.
Manman to 23,
23rd, yes.
23rd.
23rd. Please serve an advance copy so that we can deal with the matter.
Yes, I shall serve them.
Item 5.
Lordship, I'm appearing for the petitioner. I'm led by Advocate Hassanul Zaman. He's ill. I'm praying for time, Your Lordship.
On prayer of the, have you served?
Yes, Lordship. It was done.
On prayer of the applicant petitioner, the matter is adjourned. Let the matter appear under the same heading on 22nd June.
Lordship. Great.
Please file your affidavit of service on the adjourned date.
Lordship.
Item 6.
My lord, appearing for the petitioner, my lord. This is appearing for the
For the first time, please
ma'am.
serve and come back.
My lord, it can be on 20th June because the other matter was also
20th, 20, very well, very well.
20 June.
Raji, 20th June, 20.
Replay.
Item 7. Item 7.
It's a day you're.
My lord, it was a long matter, my lord. But what happens, my lord, after serving the contempt application, they all on a sudden send the compliance report. My lord, some discrepancy in the compliance report. My lord, this is an affidavit of service.
Mr. Dev, where is the affidavit? Contempt matter.
Has been complied, my lord.
Contempt matter has to be on affidavit. Let him come back. Let him come back on an affidavit. Affidavit of service. Learned counsel for the alleged contemners submits that the order under contempt has been complied with. Stop. He seeks to use an affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 21st June.
Yes,
Item 8.
my lord, I am for the cause. My lord, this is also same matter. What happens, my lord, after serving the complaint content application, all on a sudden, my lord, by email, they send the report first. Then afterwards, they send the report, my lord. No, my lord, there is a.
Your affidavit?
Even if it is not ready, my lord, but the order has been completed within time and the order has been communicated to the
Let it be
petitioner.
filed,
That is also within time.
Please come back on 21st June
Yes, ma'am.
with the affidavit.
Only one thing, they have, my lord, implemented two contemners. One is district magistrate and another is ADM, my lord, additional district magistrate. Additional district has no role to play. The lordship direction was upon the district magistrate only.
Come back on the
Why
next
they
day.
have, my lord,
Well, long-term management was granted by whom? Additional district magistrate.
Who is the contemner? Who, against whom was the order passed?
Both of them, man.
no, my lord.
I
Can you see, my lord, the order?
filed the content application in respect of both of them.
Can you see the order, my lord?
When I come to page.
Fourth respondent. Fourth
Fourth
respondent should be the contemner. Who is the fourth respondent?
So is district magistrate, no? Can you see?
The district magistrate, yes. Only the fourth respondent should be the alleged contemner.
I am not. objection. But the notice was issued in respect of stop of the mining lease has been issued by the district magistrate. That's why I made the con.
The district magistrate is the alleged contemner, not the additional district magistrate. Because the order was on the district magistrate.
Let the file an affidavit, I am not.
Even the order has been communicated through email. That is why they have filed this contempt.
To?
The order passed by the district has been communicated through email. That has been complied with within time.
communicated through mail, that is also within time. Only one that has been communicated through mail, that is why they have.
No, my lord.
communicated.
fact,
I can,
there is
this was
Okay,
all.
2 years they kept mum. After serving the contempt of application, my lord.
No, my lord.
No direction being made in the order under contempt upon the second alleged contemner being Priyadarshini S, comma, additional district magistrate and district land and land reforms officer, comma, Bankura, comma. The contempt application does not lie against her. Paragraph in view of the same, the name of the second contemner be expunged from the cause title of the contempt application. Stop, the cause title be amended. Paragraph, it is submitted on behalf of the alleged contemner that the order under contempt has been complied with. Stop, learned counsel for the alleged contemner seeks to file an affidavit of compliance on the adjourned date. Stop, let the matter appear under the same heading on 21st. 21st, same day, 21st June.
Item 9.
Please.
By APA for the respondent with Mr. SUVRA.
Madam, led by Mr. Kishore Dutta, he is on his way. Let me.
Yes.
Amrit Bharat scheme. Here's a piece.
This pertains to, my lord, initially it was a lease and subsequently, my lord, it was converted into a license, my lord, by the railway authorities. My lord, in 1905, my lord, the lease started, my lord, by virtue of a, my lord, lease agreement by the then, my lord, committee, when, my lord, of course, my lord, the railways were not there. And subsequently, my lord, it was extended from time to time. If your lordship may kindly have a look to, my lord, page 26.
Yes. This is the agreement.
Yes. But this is, first is dated, your lordship will find, my lord, 1st May 1905. Then when it goes on and on and on, my lord, I'll not trouble your lordship, my lord, all those, my lord. It goes on. My lord, at page 46, my lord, your lordship would find the last train that, my lord, my client has paid to the railways, my lord, Southeastern Railways, my lord, after, my lord, it became a railway property. My lord, in the middle of that page, on account of, then my lord, in handwriting, OFCC, FMSD, etc., for the period 2022-23.
Yes.
Now, this was last paid, my lord, on the 16th of May, 2022. Now, my lord, thereafter, my lord, we are, my lord, occupying that premises. At page 90, your lordship will find, my lord, we request them to give us the information as regards the amount that we are required to pay. Well, at page 90, my lord, this is 27th of April, 2023. But before that, what happens? Your lordship will find, my lord, at page 91. This is where, my lord, my rights are affected. It says subject is notice for vacation of circulating area of the railway lands at Kharagpur railway station area are required now for railways own station development project under the policy of the railway board named as Amrit Bharat station scheme. Now please take the first paragraph. One railway built shop measuring more or less situated at the circulating area besides the approach road towards the Kharagpur railway station, Bogda 2nd Avenue, was temporarily allotted to you. This is where, my lord, I lay emphasis. Under temporary license basis, long before, not renewed thereafter. So, but this is the, my lord, first submission which I wish to make, that, my lord, this was not a temporary one. This has continued from 1905. Then, my lord, please skip over the second paragraph. Please take the third paragraph. That Amrit Bharat station scheme has recently been launched for development of railway station on Indian Railways. Presently, the scheme envisages to take up 1,275 stations for upgradation, modernization of over Indian Railway. Under this scheme, 17 stations of Kharagpur division, including Kharagpur station, has been identified, resulting total circulating areas of Kharagpur station are now urgently required by the railways for own station development scheme under the policy of the Railway Board as Amrit Bharat Station Scheme. At this juncture, on behalf of the President of India, I do hereby give you notice to clear all railway outstanding dues up to 22-23 and to quit and deliver vacant possession of your occupied areas measuring such and such to the railways. Now, this is the now, so far as 22-23 is concerned, your lordship has seen, we have given our rent, which I placed before my lord. Now, kindly take the scheme, which your lordship would find at page 49. This is Amrit Bharat scheme, station scheme.
Yes.
Please take the fourth line from the top. While creation of city centers and roof plazas is the ultimate target for development of stations, it is essential that development as stations gradually moves in this direction with minimal duplication of expenditure. In view of the above, a new policy for modernization of stations named so-and-so has been conceptualized. Amrit Bharat Station Scheme envisages development of stations on a continuous basis with a long-term vision. Similarly, the purpose is to create roof plazas for the purpose of development of stations. Now, broad objectives, kindly take paragraph number 3, then 3.1 thereafter, thereunder. The scheme aims at preparation of master plans of the railway stations and implementation of the master plan in phases to enhance the facilities, including and beyond the minimal essential amenities, and aiming for creation of roof plazas and city centers at the station in the long run. Similar to provide amenities which are not that essential, if I may say so with respect. Now, please take 3.3. The scheme shall cater for introduction of new amenities as well as upgradation and replacement of the existing facilities. Then 3.4 says that for that purpose, relocations are required to be made. Then please take paragraph 4 in the next page. The scope of the work to meet the above objective, the broad scope of work, etc. They are given. Please take 4.7 thereunder. Space, I'm not reading the others because possibly the others would not apply, subject to what my learned friend says. 4.7, space shall also be created for executive lounges and places for small business meetings. Then 4.9, station approaches should be improved to ensure smooth access by widening of roads, removal of unwanted structures, properly designed signages, dedicated pedestrian pathways, well-planned parking areas, improved lifting, lighting, etc. Necessary liaison should be established with the local authorities for necessary improvements to be carried out by the local authorities in this regard. This is 4.9. But others, I don't think it is required. I don't trouble your lordship with those. Then, paragraph 6 at page 51 is the selection of stations. 1,275 stations have been identified, which Kharagpur is one of them. But my first respectful submission is, the basis of the impute notice that, I am in temporary occupation and that I have been temporarily allotted, in my very respectful submission is erroneous, because all the documents are here, I don't trouble your lordship. It started from 1905, number one. Number two, which was originally a lease, now, they claim it to be a license. Now, let us proceed on the basis that it is a license for the time being. Even if it is a license, your lordship knows, under section 60B of the Easements Act, licenses are revocable, but those where permanent structures have been constructed, those licenses are considered to be irrevocable. Why I say this, because I have set up, over there a petrol pump and a retail liquor shop, which your lordship would find, from page 94. And my lord, I am told, my lord, that I have also, there is also a residential building where the letter starts at page
Uh,
90.
They are set up with the consent of the railway?
Yes.
You have the documents?
My lord, I'll take your lordship through those. Please, my lord, appropriate lordship's query. My lord,
Page 43.
একটা জায়গায় আছে।
In fact, that's.
The license to people government.
But all these licenses have been given to me by the government.
43, 44.
But these are the licenses that, my lord, I have to run a foreign liquor license, retail over there at page 43. Then 44, my lord, I have been allowed to have a petrol pump, my lord, at page 44 at the bottom. Then your lordship finds, my lord, at page 45. Also, my lord, the government of West Bengal, my lord, has been has granted.
44 is not by the railways.
No, these are, my lord, the licenses that I have. My lord, these are all within their knowledge. But there is, my lord, I'll tell you, lord, show your lordship, my lord, one thing. But there is a permission, my lord. I just can't find it.
Because
out
the
right.
railway says that one
Yes, yes.
shop room was allotted to you,
Yes,
nothing more.
yes. Please take me to page 26, the first one.
Twenty-six, yes.
Please take the penultimate paragraph. The lessee shall not be allowed to sell liquor for consumption of his premises, neither shall he allow liquor to be sold if the person demanding the area is in the state of intoxication. So, my lord, this is the only prohibition. Then please take, my lord, the next page, page number 27.
Yes.
My lord, the second paragraph. The lessee shall use the building as a shop and something and dwelling house, some quarters and a cloakroom with something authority with outhouses attached. The lessee agreed to open a work a general shop as per the terms hereinafter named. Then, my lord, skipping over 2 paragraphs, then please take the lessee hereby binds himself, his heirs, and executors to rent the said buildings at a monthly rent of rupees, etc. But something is missing then. Ground floor of the same as a shop, and the upper story and dwelling house place for shop attendants, the lessees and their families. Then, my lord, one paragraph thereafter, the lessee undertakes and appreciates that the rental of rupees 60 per centum does not include conservancy charges, etc. So, my lord, this was for, my lord, permanent structures. Now, my lord, I am.
Only a shop, no petrol pump.
Yes, no, but my lord, in the meantime, my lord, we have set up the petrol pump and permanent structures. Now, these permanent structures exist over there. Therefore, my lord, the question is, first is it was a lease, then it was converted to license. My lord, I cannot, my lord, make those arguments because I have signed on those licenses. Now, my lord, if there are, my lord, permanent structures constructed over there, my lord, my very respectful submission is, my lord, the license becomes irrevocable because of section 60B of the Easements Act, number 1. My second submission is, my lord, this is not an eviction drive. My lord, under any of the eviction laws, my lord, that is permitted in this country. Number 3, my lord, this is also not the railways exercising their statutory rights under the Railways Act to remove persons who are creating obstructions. My lord, this appears to be a scheme, my lord, which in my humble way, my lord, is not a statutory scheme, subject to what my learned friend says, which is not a statutory scheme. Therefore, my lord, in order to, my lord, remove persons for this scheme, my lord, I would be very respectfully submitting, my lord, the provisions of eviction or the process of eviction, my lord, are definitely to be, my lord, taken recourse to, subject, of course, if there is a ground of eviction. So, but this is not a, my lord, statutory scheme, and, my lord, according to me, it doesn't have a statutory flavor. Neither is there, my lord, any allegation against me that I have infringed any of the conditions of the license or for any other conditions which can result in my eviction. But this is only, my lord, a so-called scheme to provide better amenities. Now, my lord, in the factual background, my lord, I will not trouble your lordship, my lord, at this stage, because it is far away from the station. But I've given a map. Please have a look to me at page 98.
Yes, 98.
Milord, at the top, your lordship finds railways, Kharagpur railway station written. Then you have the First Avenue.
Then the second avenue.
There within, after the first avenue, your lordship finds the railways office, and on the right hand side, these cubes, which are the shops. Then there's a road named Goli Road, which is called the Second Avenue, I'm told. Thereafter is our office or the premises which I occupy. In between, your lordship will find in the middle of that main building, go down plus floor, and thereafter the railway petrol pump. So, I'm far away, my lord, from the railway station. These are all facts, my lord. I will not trouble your lordship, only to give your lordship an overview of the position which I occupy. Therefore, my lord, my first respectful submission is, my lord, there is no eviction drive. Number two is there is no allegation of, my lord, infringing any of the conditions of license. Number three, my lord, your lordship knows, my lord, the law of our country is that, my lord, even if I am a trespasser and even if the landlord or the owner is the government, then also, my lord, recourse to the law has to be taken, my lord. Your lordship recollects, my lord, in there is one judgment, 1989 4 SCC 131. Unfortunately, I don't have the judgment today. My lord, in paragraphs 8 and 9, the Supreme Court has held, even if the landlord is the state, then also, my lord, proper proceedings have to be, my lord, initiated for removing a person.
There are divergent judgments.
My lord,
Supreme Court has also held otherwise in other judgments. Anyway, that we'll consider.
yes. Now, my lord, those are also, my lord, in respect of eviction drives.
Yes.
But I am not a victim of an eviction drive or a person who is sought to be evicted for XYZ reasons. Well, this is, my lord, a non-statutory scheme only to provide better amenities. But please consider, my lord, in this situation, my lord, when, my lord, I am occupying that premises from 1905, but whether, my lord, by stroke of a pen, my lord, today, my lord, I can be removed from that place or not.
Yes, sir. Yes.
Lordship, Lordships have seen that my learned friend is basically an occupant. I mean, what started off as a lessee lordship, now if your lordship sees the receipt, it's gone in, he is now occupation charges, lordship. See, next page, lordship, it gives the breakup. O fee, occupation fee. So that is what, anyway, but here lordship is, it's not that my learned friend is being singled out. It's not that we are trying to evict him because of something. Lordship, we have a policy has been adopted on an pan-India basis. We have our schemes, we have our long-term programs, how to, I mean, to make it a world-class quality. Lordship, and 1,275 stations across the country have been earmarked. And we require this. The building, I mean, what my learned friend has submitted regarding section 60B, it is permissible if the structure is built by the licensee, but the structure is built by the railways. So he was merely an occupier of the shop room. Yes, the span of time, yes, lordship, that is admitted. But for promoting a scheme, for implementation of the scheme, when we require our lands, lordship, this
The
is
petrol pump has been built by the
petrol
licensee?
pump, but the building, the shop room, the building is built by the railways.
There's a petrol pump in
Lordship,
addition to the building.
As my learned friend says, lordship, these are the details. I'll have to seek instructions. Let us proceed on the, I mean, that is sort of structure, lordship. I mean,
You want to come back on affidavits?
I think that would be better,
Or a
lordship.
report should
But
suffice.
lordship, I will only, since he's challenged the scheme and the notice, Lordship, I would just say that, Lordship, there should not be any order disturbing the scheme, because, Lordship, this is on an all India basis. I mean, not a single, it's not a 1:1 basis where my learned friend, he was there, but now it's part of, and I suppose being an occupier, he always knew that when it was required, when the government required it, then, Lordship, at best, we might give him some time to vacate. I mean, yes, he's been asked to vacate today, Lordship. Lordship, this much we can say that, but the scheme should not be disturbed, Lordship, because after all, it's not one station, it's the entire country. And this much, Lordship, yes, 17th of April, he's been asked to vacate by 17th of May, Lordship. If your Lordship so desires, let them take some time to vacate. Let them say that I will be, but otherwise, Lordship, there should not be any protection granted to them, because the entire effort is in public interest. My learned friends have placed the plazas and roof plazas and not the rest, Lordship. I don't want to trouble you, but I mean, if your Lordship goes to the scheme, there's improvement of the railways, amenities, everything. I mean, and now if you see what was there at that point of time, now with the vehicles, parking, everything has become a problem, Lordship. So the space, it's not that it's very far, it's adjoining to the station. So the space is very much required, Lordship. It's very near the Kharagpur station, and in each station, Lordship knows what goes through with the parking areas. So we will have to take all these into the scheme in its entirety, my Lordship. My learned friend has just pointed to certain parts of the scheme, but the scheme in its entirety has to be taken. And it's an all India scheme, which I don't think my learned friend can at all challenge it here, Lordship. But if my learned friend wants some time to vacate, Lordship, I'm willing to, that we can give him, because yes, 30 days he's been
That's a
given.
fair proposal.
But may I say this, my lord? My lord, we have already made a prayer for an alternative site, which
So
the
that
railway has
can-
rejected.
Yeah.
Therefore, my lord, the only asking for time to which, my lord, my respectful response is number one, but the scheme does not envisage, my lord, eviction of people. Even if it envisages, then also, my lord, it has to take recourse to some law.
The scheme has not been challenged. You cannot.
He cannot.
My lord, if the scheme, my lord,
Court cannot intervene with the policy decision of the railways.
yes. Now, my lord,
What is left?
my lord, I am, my lord, troubling your lordship, my lord, with the basic law of our country. Basic law is, my lord, putting myself to the worst position as a trespasser. Can I be thrown out, my lord, without the due process of law? My lord, your lordships have answered that no, you cannot.
Or you can.
Now the question is this applicable, or is this principle confined to only a landlord-tenant relationship, or licensor-licensee relationship, or lessor-lessee relationship between two private persons? You know, the Supreme Court has said no. It even applies where the landlord is the government. May I don't have the copy, may I only read two paragraphs of 1989-4. It is exactly on this point, and it also goes on to say damages is not the remedy. You cannot tell the licensee, pages, 89-4. 131. Well, this is still a good law. Paragraph 8 and 9. Mr. Tarkunde,
Page 231. 39 Supreme SCC, page 231. By the way,
But please take note paragraph 8.
Yes.
Mr. Tarkunde, learned counsel for the defendant, number 3. The appellant herein rightly did not go into the appreciation of evidence either by the trial court or by the high court or the factual conclusions drawn by them. It was, however, strongly urged by him that the period of license has expired. This is also a case of license. Expired long back, and the plaintiff was not entitled to renewal of license. It was submitted by him that in view of the license having come to an end, the plaintiff had no right to remain in charge of the business or the premises where it was conducted, and all that the plaintiff could ask for was damages for unlawful dispossession even on the footing of the facts as found by the High Court. We find ourselves totally unable to accept the submission of Mr. Tarkunde. It is a well-settled law in this country that where a person is in settled possession of the property, even on the assumption that he had no right to remain on the property, he cannot be dispossessed by the owner of the property except by recourse to law. If the authority, if any authority were needed for that proposition, we would refer to the decision of the division bench of this court in so and so. This court in that judgment cited with approval the well-known passage from the leading Privy Council case of Midnapur Zamindari, wherein it has been observed, in India, persons are not permitted to take forcible possession. They may obtain such possession as they are entitled to through a court. The proposition was also accepted by a division bench of this court in Ramratan. The division bench, comprising of 3 learned judges, held that a true owner has every right to dispossess or throw out a trespasser while he is in the act or process of trespassing, but this right is not available to the true owner if the trespasser has been successful in accomplishing his possession to the knowledge of the true owner. In such circumstances, the law requires that the true owner should dispossess the trespasser by taking recourse to the remedies under the law. In the present case, we may point out that there was no question of the plaintiff entering upon the premises as a trespasser at all, as she had entered into the possession of the restaurant business and the premises where it was conducted as a licensee and in due course of law. Thus, defendant 3 was not entitled to dispossess the plaintiff unlawfully and behind the back as has been done by him in the present case. It was pointed out by Mr. Tarkunde that some of the observations referred to above were in connection with a suit filed under Section 6 of the Specific Relief Act or analogous provisions of the earlier Specific Relief Act. To our mind, this makes no difference in this case as the suit has been filed for a few, has been filed only a few weeks of the plaintiff being unlawfully deprived of possession of the business and the premises and much before the period of 6 months expire. In view of the aforesaid conclusions arrived at by us, we do not propose to consider the question whether the agreement between the plaintiff and the defendant amounted to a license or a sublease. Even apart from that, we have observed above, we feel that in this case, conduct of respondent number 3 is such that we should decline to entertain his appeal by special leave under 136. In the first place, he has unlawfully taken possession, and that is in the backdrop of that case that he has unlawfully taken.
Fact is very
Situation is
different.
different.
Totally different.
Now, my lord, the principle is still valid today. And please recollect the case of Great Eastern Hotel, my lord, where, my lord, a legislation was brought by the name of Great Eastern Hotel eviction of tenants, etc., where, my lord, the state legislature had conferred powers on the authority to remove people by a statutory mandate, to which, my lord, again, the Supreme Court has struck down the statute. Therefore, my lord, if your lordship requires, my lord, I can bring those judgments where it says even the state has to follow this. That is why, my lord, the summary proceeding laws, so that the state does not have to wait till the a suit is decided. So, my lord, the basic law of our country is that, my lord, even if you, because I am not a trespasser, they don't say that I'm a trespasser. I put myself into the worst situation that I'm a trespasser. Number one, my lord, my possession is accepted, they will say temporary. Whether temporary or permanent, that your lordship can decide, my lord, during the final hearing. Number two is there is no eviction drive. There has to be an eviction drive. Number three, the scheme also does not contemplate that they can, by administrative fiat, remove person from possession. Therefore, my lord, these are the protections, my lord, which these citizens of our country enjoy. Therefore, my lord, I very respectfully submit, my lord, unless they obtain an appropriate orders, my lord, I am not here to advise them which will be the appropriate authority. But the railways cannot take possession even of their own premises wherever it is. This has long been settled.
Please give me a copy of this authority.
Yes, but this authority, if your lordship permits me, I have not placed those. There are other two authorities, including the Great Eastern one. If your lordship permits me, I can serve copy on my learned friend and hand it up to the court by the end of the day.
Please do that because if I may share my mind, the railway has a good case. So if you want to.
I'm sorry, my lord.
the railways have a good case. So if you.
Yes, but the railways, may I, my lord,
I would actually like to share my mind because
Yes,
you can
I-
come back with those.
yes.
varieties.
well, I'll tell you, Lordship, my lord, the railways have a right. But that right is also circumscribed by a procedure. The right, my lord, every 10 landlord of this country, private, public, statutory authority, whatever it is, my lord, they have a right to remove people from respective premises. But the law is different in case of public premises and private premises. But my lord, the law for evicting, whether it is a public premises or a private premises, my lord, in both cases, my lord, a procedure has been laid down. Now, my submission is that, my lord, for the present, because since, my lord, I am pressing for an interim order, that procedure has not been started even. That procedure has not been adopted even. But I can understand that there is an eviction order, right or wrong, there is an eviction order. Then, my lord, of course, my lord, the challenge becomes very restrictive on the validity of that eviction
Let
order.
the railways come back with instructions.
Lordship, let him
Let
supply
there be an interim order till the adjourned date. I'll
till the
consider-
adjourn, till the adjourn
Right.
date. then, Lordship. Only for, yes, a limited period. Only for the occupation part, not the other. I mean, the prayers are in
The
twofold. The
notice will be stayed.
only the
Yes,
notice,
yes.
Lordship, only the notice.
Insofar as the petitioner is
Right.
concerned, till the adjourned date.
Yes, just for a limited period, Lordship.
The
Well,
petitioner
may I take your lordship's limit?
claims to be a license under the respondents by virtue of an agreement executed on 1st May 1905 and is admittedly in possession of the premises in question, which belongs to the railways. Stop.
Lordship,
The petitioner has cleared license fees for the period
occupancy charge, Lordship, occupancy charges.
23.
It's
Occupational charges
occupation.
for the period 2022-23. Stop. The petitioner has been served with a notice by
That
the
is,
railways
that is
on
prior to
17th April 2023, requesting him to vacate the premises in question for the purpose of implementation of Amrit Bharat Station Scheme, quote unquote, introduced by the railways. Stop. The said notice is assailed in the writ petition by the petitioner on the premise that the notice cannot be termed as a statutory eviction drive by the railways. Stop. The scheme does not lay down issues which are such that immediate eviction of the petitioner is required. Stop. Also, comma, there is no allegation of infringement of any of the clauses of the deed of lease. It's an agreement, isn't it? Any of the clauses of the agreement by the petitioner. Clauses of the agreement by the petitioner. Stop. Paragraph. Per contra, comma, it is submitted on behalf of the owner, a learned counsel for the petitioner further submits that since the petitioner is in settled possession of the property since long, comma, law does not permit eviction of the petitioner therefrom without proper the petitioner cannot be evicted therefrom without taking recourse to due process of law. Paragraph per contra comma, learned counsel for the respondents submits that the premises in question is urgently required by the railways for implementation of the scheme, implementation of the policy, Amrit Bharat Station Scheme. Stop. You referred to 60B also, isn't it? Learned counsel for the submits. Petitioner submission. Learned counsel for the submits that in terms of the provision laid down under section 60 capital B of the Easements Act, comma, 60 capital B of the Easements Act, comma, license of the petitioner is irrevocable in view of the fact that the petitioner has raised permanent structures in the plot in question. That was your submission.
Well, the structure was there when the lease was granted. The structure was
That was
standing.
the submission.
But your submission was that you have raised structures.
No, my lord, we have built the petrol pump and the shops after the lease, but the structure was standard. We have been maintaining and
So this is not applicable.
Lordship, my instructions are otherwise. The structure was there.
the structure was
That
standing.
was a railway structure.
In view of the fact that the
I had a heart.
in view of the fact that the petitioner has
Small portion.
started a petrol pump in the plot in question and has been maintaining the structures standing thereon.
ওখানে কবে সুপ্রিম কোর্ট যেতে হবে? ওনাকে স্কিম নির্দেশন না করতে হবে না, আপনার বলতো স্কিম চ্যালেঞ্জ করা নেই কি করে কিছু করে দিয়েছি বলছে স্কিম চ্যালেঞ্জ করছে।
It was giving you a heart, but a Nilina heart.
And
নাম্বারটা সেভ করে রাখো, এটা
any order granted in favor of the petitioner shall affect
ছবি তুলে দেখানো।
implementation of the policy nationwide. Policy nationwide.
Actually,
Paragraph.
you've come early.
It is not in dispute that the petitioner is in occupation of the premises in question as a licensee under the railways. Stop. You want to come back with instructions in this matter?
Lordship,
But not necessarily.
but my submission will, this entire submissions are extremely premature. I mean, it's just a notice and he can't challenge the policy, Lordship. So
The notice directs eviction, isn't it?
notice directs edition. Yes, that it has to be, Lordship.
Is it really premature?
No, Lordship. I'll have to come back with instructions because what he has
Learned
stated,
counsel seeks to-
all the details relating to the
Absolutely.
property, I
seeks
don't
to
know.
take instructions in this regard.
Affidavit করলে দিন না, instruction দেই থাক। দরকার কি? একটা চলে যাবে। কম কম করে হোক।
Occupation of the since long. Since the notice impugned issued on 17th April 2023 is under challenge, comma, let there be an order, let there be an interim order at this stage restraining the respondents from but again, staying operation of the restraint, again, staying operation of the notice impugned till the adjourned date. Paragraph, let the matter appear under the same heading on 20th June.
My lord, kindly directs till the matter is taken up for hearing.
That is
Next.
on adjourned date.
The 28th June, my lord, if the matter is due to paucity of time, if the matter is not taken up again, I have to come up on an application, my lord.
Have to
Only
adjourn.
for that.
Till the matter is taken up for hearing next.
Grateful, my-
But kindly fix a date, otherwise.
Yes, well,
this is
we,
going to-
that, we don't oppose to that.
Paragraph affidavit of service.
Leave, leave, leave.
Grateful, my lord.
Leave. Now.
Item 10.
I appear for the petition. Yeah, আছে?
Yes.
Lord,
Say your appeal?
I am for this.
Yes.
the state respondents are the only respondents, my lord.
Yes.
My
What
lord,
is the matter about?
here the petitioner was granted the lease, my lord, for quarry of Blackstone. But the lease was executed on, my lord, but actually, my lord, 2nd May 2019. But there are, my lord, related permissions to be obtained, my lord, under the relevant rules, my lord, which was, my lord, lastly granted on 14th of August 2020. But only after 14th of August 2020, the petitioner could start operations of, my lord, mining of Blackstones. Now, in the meantime, my lord, the COVID, my lord, the lockdowns and other restrictions came into force. Virtually, my lord, petitioners could not operate, my lord, even till, my lord, 2022, my lord, in full swing. Now, suddenly, my lord, a notice came. My lord, if you also kindly straight away take, my lord, page 85.
Yes. Yes.
My lord, a demand was made, my lord, kindly take, my lord, may I read, my lord, as per audit observations under Rule 21(1)(e) of Minor Minerals Rules 2022 and Clause 3B of Part 7 of the lease deed, short extractions of 4,57,738 cubic meter of Blackstone for the period from financial year 2020 to 2021 and 2021-22. And therefore, the penalty was imposed, my lord, to the tune of 4 crores, my lord. You also will find this is to inform you that a sum of rupees 4 crores, my lord, have been imposed as penalty. My lord, before impositions, there was no notice, no show cause, my lord, no hearing. Straight away, this imposition came. My lord, first objection is Rule 21, my lord, 1E is no longer surviving. My lord, because rules have since been, my lord, repealed in 2016. Now they have quoted these rules, smaller that rule, smaller original rule provided for penalty. Your lordship is well aware if it is a penalty, it's a punishment. Smaller it requires a smaller pre-adjudications. But I have something to say that why I could not. Now this lease agreement, smaller this clause remains in the lease agreement because this agreement is in old format. Kindly take, my lord, page 51. The lease starts from 43. Kindly take, this is the clause 3B. Kindly first take page 50, bottom. This is clause 3 starts, this is the part 7 of clause 3. Clause 3, then B is at page 51. Second paragraph, the leases shall extract and dispatch minimum 2,60,000 such and such cubic meter or 6 lakhs metric ton of stone
from the leasehold area per annum, failing which penalty to the tune of double the amount of royalty that should have accrued on the shortfall quantity shall be realized from the lessee at the end of the year. Or even if we proceed, my lord, on the basis, my lord, forgetting these rules, my lord, which they cited, now under the new rules, there is no such provisions of imposition of penalty for the shortfall. My lord, now even if my lord, we suppose, my lord, this the state government, the competent authority,
Has a clause, yes.
yes, lease has a clause and they have the power, but it also presupposes a penalty. But penalty, when it is a penalty, my lord, it requires hearing. Because I have shown, my lord, I have given representations to them that why I could not lift. Because the first of all, my lord, the permissions came in August 2020. Then before I could start operations, my lord, the COVID restrictions came. I was prevented. But that aspects to be, my lord, gone into by the authority. But that, my lord, unless a so cause is given, unless I am given an opportunity to reply, my lord, how they can straight away impose the penalty.
My lord, he filed an application, my lord, that application should be considered.
Now, what the problem is, my lord, problem is, my lord, because of non-payment, my lord, they close this portal. My lord, I am prevented from accessing the portal. Unless I access the portal, pay the royalty and the transit, obtain the transit part, I cannot, my lord, excavate. Now that has been stopped. I have pleaded in paragraph 21. My lord, it has started from my lord, on 6th of December 2022, it has stopped. Then we had to pay, my lord, rupees 50 lakhs, my lord, without prejudice. And they're only on payment, my lord, they permitted us to access the portal. My lord, as soon as, my lord, my lord, unless we pay this amount, they have said, my lord, it will be permanently stopped. Then we will not be able to execute, my lord, excavate Blackstone. Because unless the transit pass is issued, my lord, on payment of royalty, my lord, I cannot operate. Now that payment was made, my lord, only on, my lord, compulsion.
My lord, as the application was filed, my lord, and he is restraining from 22nd December, September.
No, thereafter it was open. After it was open.
My lord, within
Yeah,
certain short period.
then kindly
the
take, my lord,
application
page 128 then. Page 128.
So now it is open and.
Now kindly take page 128. Now it is open. Now kindly take, my lord, this notice we have received. Unless we pay within 7 days, that was the, my lord, directions given, my lord, it will be again stopped. My lord, I can rely on a judgment, my lord, this is the age-old, my lord, the 5 judges bench judgment of the Honorable Supreme Court, that when it is a penalty, my lord, it requires adjudication. It is a settled law. And there is no adjudications, my lord, nothing, no so cause, nothing. I have pleaded in the petitions also. So these, my lord, demands should be stayed, my lord, let them proceed in accordance with law. So that I could explain, my lord, my stand.
Yes.
Submit that thing, my lord.
Let this be set aside, the notice impugned be set aside, and let the authority revisit the issue
No, my lord, that is
upon
the,
hearing the petitioner.
will consider the representation, my lord.
That will not serve my purpose, my lord, because if the demand remains, my lord, without adjudications, my lord, it has to be set aside.
No, it will be set aside.
Yes, my lord.
So they is not objecting to that.
Yes.
He say after setting it aside, where is your representation? Have you
My
given?
lord, I have represented, my lord, after this, my lord, demand came.
Yes.
Yes, my lord, that representation, my lord, kindly
That
take
is page
86, my lord.
Next page of
86 to 126, detailed representations has been given as to why we could not, my lord, excavate, my lord, during that period.
So let this be considered upon hearing you.
Yeah, as you lordship. And that demand be set aside, and I should be, my lord, allowed to access the portal.
no, my lord, that within.
Otherwise, I could not, then again penalty will come.
The representation be disposed of, then the question of accessing to portal.
Yes,
No, the portal is, I am still allowed. I am still allowed. My lord, it is not that it has been stopped.
Set aside, there is no question of.
No,
portion
no,
to
yes,
portal.
yes.
That's consequential.
That no observations need to be made.
Yes. If the notice is set aside, portal will remain open.
Affidavit of service to
The petitioner was granted long-term mining lease for a period of 5 years.
Didi,
Reading
affidavit of service.
the deed was executed on 2nd May 2019.
Yes, my lord. At page, my lord, it starts from, my lord, page 43.
Dated 2nd May 2019. But the petitioner was unable to
My lord, that is
comment.
this. My lord, because the permissions from Ministry of Labor and Employment was granted on 14th of August. My lord, kindly take page 79. Only after that, my lord, I could, my lord, operate. Otherwise, there are various permissions to be obtained. My lord, the last of permissions was granted on 14th August 2020. Page 79.
This is permission by the
This is permissions, my lord, by the Ministry of Labor and Employment. This was granted. You also will find the first page, right-hand side date.
and permission from the Ministry of Labor and Employment was granted to the petitioner
My lord,
on
79, right-hand side top. 14th of August 2020. Right-hand side top, just before the, just
14th August 2020, after which the petitioner was able to commence mining operation. Stop. Due to advent of the COVID-19 pandemic thereafter, comma, the petitioner was unable to continue with mining operation for considerable period of time. Stop. The Additional District Magistrate and District Land and Land Reforms Officer Purulia issued a notice upon the petitioner on 22nd September 2022 directing the latter LATTER to pay penalty of rupees 4 crores 85 lakhs 4,85,20228 for short extraction of Blackstone for the period 2020-2021 and 2021-2022. Stop. The said notice is assailed in the writ petition. Paragraph, it is submitted on behalf of the petitioner that no opportunity of hearing was granted to the petitioner prior
page
51.
51. My lord.
Authorizes the lessor to charge penalty to the tune of double the amount of royalty for shortfall in extraction of Blackstone, comma. The petitioner ought to have been given an opportunity of being heard prior to imposition of such penalty. Stop. The petitioner submitted a representation before the concerned authority in this regard on 17th October 2022, which is yet to be considered. stop the petitioner prays for a direction upon the authority to consider the said representation and grant him an opportunity to explain the alleged shortfall in extraction. Paragraph. It is submitted on behalf of the respondents that who should be the authority? The ADM.
Respondent number 4. ADM. Respondent number 4.
That the fourth respondent be directed to consider the representation of the petitioner in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the in view of the above, the notice impugned issued on 22nd September 2022 is set aside. Paragraph. The fourth respondent is directed to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month.
Yes, ma'am.
From the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Grateful, my lord. But affidavit of service filed to, my lord, to keep.
Yes. Item 11.
But there was a direction to file report, my lord. Right.
There was no direction. I think, Mr. They wanted to come back with instructions.
Is the first step
আগে একবার একটু check.
আগে হয়েছে?
But facts, my lord, possession was taken, thereafter, my lord, no award was passed. Subsequently, my lord, the notice under subsection 3A of section 9 was issued, my lord. Hearing was done, my lord, but nothing has been communicated, nothing has been passed. No order has been passed, my lord.
So report is necessary.
My lord.
Mr. They
1 minute. Page 49 to 50.
But page 49, my lord, in its similar circumstances, my lord, this order was passed by your
9(3)B
lordship,
was issued.
my lord. Self-same, my lord, scheme, my lord, direct purchase was ordered, my lord. For some of the,
All the more reason for taking instructions.
my lord. That is the reason, my lord, that most probably, my lord, the written order was passed, my lord. What is it? Yeah.
My lord, I can file a report in the form of.
But let it appear at the top, my lord, after vacation, my lord.
It's being taken up. Learned counsel for the state respondents seeks to take instruction, seeks to submit a report in the form of affidavit in this matter. Paragraph. Let the matter appear under the same heading on 22nd June.
My
Yes, ma'am.
22nd June.
তিনটে আছে তো এই আমাদের তিনটে আছে
হ্যাঁ, তিনটে আছে।
তিনটে
আমার তো আইটা ছিল লিখিত অর্ডার পাস হয়েছিল যে রিটেন হ্যাঁ আমারও তাই
দেখছিলাম না হয়তো
Item 12.
সেম মানে 12 11 12 and 13
13. Mr. Ray is appearing in all the matters?
No, madam.
12, madam, I am happy.
Same order, 11, 12, 13, same order.
Item 14. Lord, I'm for the state respondent, my lord, I got the report, my lord. Sir.
Petitioner, your appeal?
Madam, report টা একটু দিয়ে দেন।
So far, my lord, the petitioner before lordships are awardee under the Land Division Act page 22, my lord, you'll find their name has been there in the award list. Individual payment notices are issued. At the petitioner was aggrieved by the quantum. So accordingly, my lord, they filed an application to the office of the Panchayat and prayed for enhancement of that for the purpose of reference. My lord was pleased to dismiss the application holding no, it is not the authority, page 24 P5. My lord's order on the previous occasion. So my lord was pleased to hold that it is not maintainable because it is not the authority under the Land Acquisition Act. Subsequently, my lord, your lordship find page 26 that so far the amount which was earlier which was awarded in favor of the petitioner be disbursed to the petitioners because they have protested regarding the quantum and they prayed for the same, but now they are willing to accept the, my lord, the said.
They are willing to accept this. Sir.
Yes, my lord. Now there is no other option. It cannot be made in view of the limitation. রিপোর্ট আমাদের মনে দিয়েছিল নাকি দেখতো বাবু এপিটোপিট অফ সার্ভিসটা মানে the report মানে I don't have any স্যার কপি আছে একটা
Have you served a copy? Non-verified awardees.
Yes. So required verification to be done.
Yes, definitely.
It is the
Phase of my report, my lord. They have not submitted the application within 6 months, my lord. They have submitted the application.
They do not want to submit an application any further. They are ready to accept the amount, verify their identity and pay the amount.
yes, because already it was decided by your lordship. So
Affidavit of service. Of a status report submitted on behalf of the state respondents is taken on record. Paragraph, it is not in dispute that the plots in question were acquired. LA case number 4/24/2010-11. Dated 30th November 2010. And the petitioners have been declared as non-verified awardees for consideration of payment of compensation. Stop.
that is a
Paragraph, learned counsel for the petitioners submits that the petitioners seek to receive the amount of compensation decided by the authority in their favor and have submitted an application to that effect before the concerned authority on 16th December 2022. Submitted on behalf of the respondents. Special Land Acquisition Officer.
Yes, ma'am.
That the fourth respondent be directed to deal with the application submitted by the petitioners and take necessary steps accordingly. Paragraph, in view of the above, the petition is disposed of, directing the fourth respondent to consider the application submitted by the petitioners dated 16th December 2022 and take necessary steps for disbursement of compensation in their favor upon the petitioners submitting necessary documents in support of their claims.
Their identity matters. So the names are there. Well, identity claims
In support of their respective claims. That will include everything. Disposed of. the paragraph, the entire exercise should be completed
Within 2
Within-
months.
within 2 months from the date of communication of this order.
Every service be kept in the record, my lord. Grateful to your lordship.
But I beg to appear on behalf of the petitioners. But this is my affidavit of service. But I have prepared a supplementary affidavit. My lord, annexing the documents post filing of the writ petition. My lord, I have served the copy of the application upon learned brothers.
আমাদের একটা কপি দাও।
Sir, আপনাকে দেওয়া হয়নি? ঠিক আছে, আমি আপনাকে দিয়ে দিচ্ছি। My lord, the short fact relates to, my lord, if my lord may kindly turns to page 13. But this is I am the owner of the land in question, which I have purchased from the erstwhile owner, which your lordship will get at page 13. This is the purchase deed of 2011, page 13. My lord, may kindly turns to page 13. Thereafter, I will take your lordship to the prayer portion and the other documents. Page 13 is my purchase deed. But the name of the purchaser is written as Shukenbach, who is the writ petitioner before your lordship. If my lord may kindly turns to page 15, the scheduled property. Dag number is given in Bengali, my lord. It written 3680 at the bottom, left hand side. But this is the Dag number which I have purchased from the erstwhile purchaser, and I have made construction thereupon. If my lord may kindly turns to the page 23, the map that is annexed with the purchase deed. This is the map.
Yes.
My lord, your lordship will see on the right hand side, there is a rectangle property with named as 3680. My lord, it has been duly signed by the member Piplion Gam Panchayat, right hand side. And the bottom, my lord, the surveyor signature is there, and the other person's signature is there, and the person who is the private respondent, its name appears at the bottom, serial number 4, Hemonto Hajra, at that very page, my lord, page.
I'm for the private respondent.
But this person, it is been recorded in front, that recorded Rasta. I have brought the Mauja map. It is the recorded Rasta, which is the public road, PWD road, and this Hemonto Hajra, who is the private respondent before your lordship, Mala, he is making construction in the name of some other government project, who, although he is not a government employee, not a representative of any authorities, who has been made it as in the array of the respondents. Mala, he is blocking my egress and ingress to the property and threatening me with dire consequence if I prevent them from making the construction.
So you treated the panchayat also as a party?
Yes.
Have you served
Now,
the panchayat?
yes. I have served all, my lord. Kindly see my representation, my lord. I have made 2 representations on 23rd of June 2022 and 12th of December 2022. All representation I will not take your lordship. My lord may kindly turns to page 29 once. 29,
Give me a minute, please.
my lord.
Give me a minute, please.
Yes, my
Where is
lord.
your service upon the panchayat?
My lord, affidavit of service I have filed, my lord. Pradhan is respondent number 6, Piplion Gam Panchayat.
Yes, but please show me the service.
May I just assist your lordship? এটা affidavit service টা দিন, আমি একটু বার করে দিচ্ছি। Well, the state respondent is being represented. He is also he will, my lord, may I just,
Panchayat is
may I
not
just-
represented by the state. Separate entity.
my lord, I have served the private respondent as well as the officer in charge.
Yes, I do not find the pradhan.
Pradhan, my lord, perhaps it has not been served. My lord,
Serve and come.
may I, sir? But only, my lord, my prayer is not against the Pradhan.
Will you expunge his name?
My lord,
Otherwise you have to serve.
very well, my
You
lord.
have implemented, you have to serve.
I will serve. I will serve. এটা রেখে
Let the service be complete.
My lord, In that event, my lord, may kindly record, my lord, the private respondent and the officer in charge and the state has been represented.
That's there.
ভিডিও আরে ভিডিও কে বলো না ভিডিও কে
Only the Pradhan has not been served.
My lord, in that event, 4 and I will serve 4 and 6. BDO is there.
BDO is represented by the state. Only the Pradhan. But the state doesn't represent the Pradhan actually.
Very well, my lord. I will serve the Pradhan.
Affidavit of service and supplementary affidavit filed by the petitioners. Are taken on record. Paragraph, since service upon the sixth respondent is not complete, comma, let the matter stand over till 22nd June.
But my lord, may kindly record the affidavit, supplementary affidavit I have filed. 22nd.
It's still.
My lord, my lord, can it be taken on 23rd? I have a personal request.
23rd. Others are there, 23rd. 23rd. Yes.
Please, your lordship, my lord.
Have you served the secretary?
I have, my lord. This is my affidavit of service, my lord.
For conducting file supplementary affidavit.
Yes, my lord. My lord, what
Have you?
the problem is, my lord, the deponent is about 60 years old. He's gone, he's had a unfortunate incident, my lord, which is why he's relegated to. My lord, what I was praying for, my lord, is if your lordship is kind enough, this is with regards to, my lord, extension of refusal or rather non-consideration of my prayer for extension of the time period with respect to mining lease, my lord. My lord, what I was praying for, my lord, if they have not considered it, if your lordship is kind enough to, my lord, relegate it to the concerned authority and grants me the leave to, my lord, whatever documents that I wish to rely upon, I'll rely upon them at the time of hearing, my lord. I think that would subserve the
Your
purpose.
representation is pending.
Of course.
This is your last occasion, Mr. Chatterjee.
Mr.
appeared
Chatterjee.
without the petitioner, he submitted that I don't want that.
We did not want that, but
I
because,
want
my
the
lord, all of,
adjudication of the dispute before your lordship. So instead of referring the matter to the ADM, he submitted that I would add the secretary ICE department as respondent and would like to use a supplementary affidavit. Yes. Lordship can, I am not stand.
all of our good conscience faith at the time of, my lord, because that, but in the meantime.
Where is your?
Adjudication চেয়ে এখন
You have 2 representations pending. The later one will suffice. At page
Number 90, page
90.
annexure P4.
So if he wants to rely more document, it would be easier for him to submit a comprehensive representation and to enclosing all this document he want to realize.
Sir,
But it will,
Lordship.
My
produce
lord.
documents before the authority.
Absolutely. My lord, I just have one.
Detailed representation, I find.
It is, my lord. Just government notifications, nothing beyond that. My lord, I had just one other prayer, my lord. My lord, I am in possession of the plot. Of course, I cannot carry out minings because the challans cannot be issued. My lord, till the time period where the representation is being considered and thereafter till the order is being passed, my lord, may I not be dispossessed from the plot or may it not be put up for auction? Because this is, my lord, a little different from the usual sand mining matters. I'm not just on force majeure, I'm also on the.
The period is over, it's a-
Yes,
But this
January.
was, but my lord, this was filed within the period. This writ petition, my lord, was taken up before the lease expired.
No, Lordship, the lease expired on 17th of January and the petition was filed on 22nd January.
It's filed 4th of January.
But Lordship, it appears from the copy served. Oh, Lordship,
The representation.
It might have been served, my lord,
representation is within time.
And there was an earlier representation also.
earlier, November.
It appears from the affirmation date 20th of January.
The writ petition.
Yes,
The representation was.
representation is within time,
That is
but the writ petition has filed after expiry of the petition.
considered.
No, he said that I filed
No,
the
my lord,
petition
what-
within the
No, my lord, what had
limitation
happened, the
period.
lease is dated 15th of December, but I was subsequently put into possession. My lord, my instructions are, my lord, this was filed within time. Before the, my lord, the lease expired.
Let this be considered.
But in the meantime, my lord, your lordship would, my lord,
Yes.
be kind. I'm
So
sorry.
if that the auction price is not there, Lordship, kindly do not pass that order.
My lord, I have
If he is in possession, let
possession.
him remain in possession
Very well, ma'am.
till the
That would-
disposal of
that
his
would-
representation.
Respect of possession.
Lordship,
Very.
that will.
Affidavit of service. The petitioner was granted long-term mining lease for a period of 5 years. V-Day deed of lease dated December 15, 2017, which expired on December 15, 2017, with effect from January 22, 2018, January 22, 2018, which expired on January 21, 2023.
Execution after January 1.
The petitioner
In December. বুঝবি না কেটে কিছু করতে থাকি
submitted a representation before the concerned authority requesting extension of the lease and allowing him to continue with the sand mining operation on 4th January 2023, requesting. It is yet to be considered. Stop the petitioner, prays for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the respondents that the fourth respondent.
ADM.
The fourth
ADM the
respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month
1 month apart.
from the date of communication of this order.
6 weeks.
Upon affording reasonable, 1 month is sufficient.
Sufficient it is. If there's a standard order, I know I'll.
They will file a contempt
Now it's being modified to 6 weeks of late.
The usual orders which are.
6 weeks.
6
I leave it to lordship.
Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Stop, the petitioner is at liberty to produce relevant documents in support of his claim before the concerned authority at the time of hearing. Paragraph pending disposal of the representation, let there be an order of status quo upon both the parties in respect of possession of the plot in question as on this date. A paragraph, the decision taken by the pending decision taken by the authority shall be communicated to the petitioner within a week.
My lord, I was praying for my lord urgent photostat certified copies because my lord, the server is my lord has been dysfunctional for a while. Because very well, I'm grateful, my lord. Because the orders, my lord, are very well. I'm grateful, my lord.
Seventeen.
17, my lord, this is my application.
Yes, a report has been submitted.
Yes, your lordship. Kindly seize the last order of this honorable act at page 15.
Hey, now. Page 15. Yes.
On file.
Yes, you go.
This is the order, earlier order.
একদিন হয়েছিল নাকি?
না, ওটা আগের order।
ও আগের order।
Thereafter, the district magistrate asked me to appear before him. My lord, page 17. Thereafter, it was opined by them that they are going to purchase it on direct purchase policy. My lord, we are not agreeable to that because
You are not agreeable.
agreeable to that. Because direct policy is for the purpose of taking over the position. There would be a negotiation between the parties. But after the everything is over, now they cannot say we are going to direct purchase. Therefore, only option left open to them is to acquire it. That was the intention of the earlier order. Compensate or give the damages for the period for which you have deprived the petitioner. This is the order. The state has to take over the land with the proper procedure of law. That is the new Act 2013. Let them do so, my lord, I don't have. Admittedly, they have taken my position, taken over the land.
What does the report say?
Report. The report.
আগে হয়েছিল না?
এর আগে একবার হয়েছে। আপনারই তো রিপোর্ট এটা।
ফাইলটাই তো পাচ্ছি।
রিপোর্টটা সবাই দিও আপনাকে জেরক্স দিচ্ছি।
Do you have a copy of the report?
Yes, I have. দাঁড়া, এখানে অর্ডারটা
Yes, Mr. Dey.
Yes, my lord.
Yes, what is, they are refusing to sell the.
Yes, my lord. As the rule is not framed, my lord, so it is not possible for us to admit that we can start proceeding under a new act, my lord, only
The
for that.
option of direct purchase goes because
Yes,
the
yes.
petitioner is not agreeing to it. So the other option is acquisition.
My lord, that is the rule is not framed, my lord, up till now. Only for that. Your lordship can pass the order.
Rule for?
The rule of the act, new act, my lord, was not formed. As because.
নিউ একটা রুল হয় না?
না না কোথায় হয়েছে? রুল হলে আমরা
একটা দাও।
তাহলে তো খুবই ভালো। রুল হলে তো
42 অর্ডার দিচ্ছি।
হ্যাঁ একটা রুল। My lord, your lordship can, my lord, I submit before your lordship that as rule is not framed up till now. So it is not possible for us to give the money to him, new rule, my lord. So my lord, your lordship can pass the order, whatever your lordship. I have nothing to say except this.
তাই তো।
কম্পেনসেট করে যেটা ইউজ করেছে ভাড়া হিসেবে।
You're disputing the ownership, the title of petitions.
No.
Your report says so, but the order doesn't say so.
And that is the ownership is the another thing, my lord.
The report that you have submitted, you have disputed the ownership.
No, not disputed. They have mixed something otherwise because initially that land was of Somarendranath Rai. After demise, the Tulsi Rai and the son are the owners. And some portion, 2.5, that was entrusted to an Jadav Chandra Das. He also gifted that portion to petitioner number 2. Therefore, now presently, these petitioners are the absolute owner. There is no dispute.
That is that part, my lord, he can prove
At
that.
the time of acquisition, we will be served notice, we will prove our case. Taposh Rai and Tulsi Rai, they are the my lord, son and wife of Samarendra. Samarendra is the actual owner. And Sumit Saha purchased from on Jadov Chandra Das, who was owner of 2.5 days.
The earlier petition was by Jadhav Chandra Das.
And another.
Who is that another?
That another is Tulsi. Sorry, my lord, no, Samarendra. Jadov Chandra Das and Tulsi Roy. Samarendra died. Tulsi Roy,
Taposh Rai was not a party there.
not part.
The utilization is admitted.
Yes.
That is not the question. As my lord, direct.
And
purchase, we-
project also started. From 2014, project
There is
started.
no any dispute, my lord, about our utilization of the land. So
Without due process of law, admittedly, they have taken over the property.
So there is no, acquisition cannot be initiated unless rules are framed.
Unless rules are, then
so your lordship
Then
can pass
it
the
is-
order, my lord, according.
What is
Yes.
the remedy?
remedy, the land has to be returned back.
I'm
Because-
asking for a practical remedy, sir.
Well, the practical
on paper.
remedy is, well, let there be a negotiation for direct purchase, because they have to approach me. We are to consider their approach. Well, otherwise my land valuation is more. They will be providing only some few.
The PHE is willing to purchase, you are not agreeing.
That, my lord, their policy is according to the present market value of the ADSR. My lord, my contention is that valuation is no more there. Purchase is being done in a higher price. Government valuation is low.
My lord, it is a very vague submission
My lord, if
from my lord as because
many
my
of the
lord.
lands in that area,
If you are agreeing to negotiate, will you file a representation before the authority? Stating your demands, your claims?
well, my claim, my lord, I can ascertain and tell them, your lordship kindly grant me after vacation. Well, I will come back with the valuation of deeds.
That has to be dealt with by the authority, not by the court. You can at best submit a representation before the authority or with all the relevant documents, agreeing to direct to purchase, to agreeing to the proposal of direct purchase.
Including the,
The authority can deal with, you can negotiate with the authority.
my lord, the
Because otherwise, it
In
has to
that-
remain as it is.
in that Moja, there are many, my lord, sale deeds of at present. Well, at that valuation, let them consider it.
My lord, he can file that application, my lord, and showing all the deeds in enclosing. That will be considered by the.
Your writ petition prayers are also not,
They are catching.
you say it was taken over, acquired without due process of law. It was not acquired. Please see prayer A.
Without following this.
Prayer B also cannot be considered.
Taken over or acting.
To award adequate compensation, that is prayer B.
Under the 2013 Act, that cannot be considered at the moment.
Well, let it be after vacation. Well, let me come back. We mean several orders being passed by this.
The option is direct purchase.
Well, after.
Wait for the rules to be framed.
Well, let it be after vacation. Let me come back. Because আপনি একটা কপি দেখেন ওই ঘরে যে অর্ডার গুলো
My lord, may I be permitted to take leave?
ডাইরেক্ট পারচেজ
Not in dispute
সেই অর্ডার দুটো
that the land of the petitioners has been utilized by the PHE department without acquisition. And the department is ready and willing to purchase the land from the petitioners in terms of the direct land purchase policy of the government. Stop. Paragraph it is submitted on behalf of the respondents that since rules under the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013 have not been framed as yet, comma. No step can be taken for acquisition of the land in question. Stop. Question at present. Paragraph, learned counsel for the petitioners seeks to take necessary instructions in the matter. Paragraph, let the matter appear under the same heading on 22nd June.
Sorry.
22nd June.
18. Just item number 18, where Mr. Manna is appearing, and kindly make it not today.
I'm for the union. After
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 23rd June.
Great. My lord, can it be 23rd June? Can it be after 25th, my lord?
After 25th,
26 or 26?
26th June. 26th.
19.
19, my lord, I'm appearing for the petitioner. My lord, on the earlier occasion, my lord directed, my lord, the authorities to file a report. My lord, the report was to the extent, my lord, I said that, my lord, the writ petition is, my lord, challenging, my lord, an order passed by the BLLRO in, my lord, proceeding of recording.
Have you served the private?
Yes, affidavit of, my lord, we have handed over the affidavit of service. My lord, the only question was whether I was served or not. My lord, to that extent, my lord, my submission is. Otherwise, my lord, there are provisions of appeal. I have to go before the appropriate authority.
You were served what?
My lord, I was served with the notice to be present in the hearing.
What hearing is it?
My lord, this is hearing with regard to, my lord, correction of the record of rights. Now, my lord,
Is this court of jurisdiction?
my lord, if there is a violation of natural justice, my lord, court has. My lord, there is catena of decisions. My lord,
You
without,
say that you were not called.
yes, I was not called.
The 23rd, two orders,
Yes.
23rd September and where are the two orders? Please show me.
My lord, kindly turns to page 21, it I 19 too. Page 21, this is the last order.
Order
Of the authorities.
mutation case, there is a provision of appeal.
Order number 12/76/2022. My lord will find, yes, on that respect, my lord called for a report.
19 and 20 is the similar matter.
Similar. No, some factual differences.
He has challenged the order passed in mutation case. His allegation is this notice has not been solved. If any order passed, my lord, by any authority, it is the under the specified act. There is a,
If notice is not served.
but
it's
there is a
violation
provision of
natural
appeal, my
justice.
lord.
Violation of natural justice, the writ court.
There is a provision of appeal, my lord.
If
Whatever may be, my lord.
Third and.
But it appears from the record, my lord, the order, see, the notice has been solved.
That is for the exactly reason. Yes.
Notice has been solved.
Page 21, my lord, it has recorded in the order, my lord.
Ground on which the report. was
দেখা
filed.
দেখা 18 দেখা
Please show
Notice
me
duly
documents
served, my
that
lord,
notice
service
was
written
served.
My lord,
filed with the case record.
19 টা দেখা
Page 21, my lord.
I've seen that, but show me the documents. That notice was served. Only this recording will not do.
But this writ petition, my lord, I'm objecting, my lord, this is not maintainable before this honorable without
On
jurisdiction.
the earlier petition also the same point was raised.
Well, I
and
was not there, my lord.
the
He has
report
submitted in
was
the.
called for to show that the notice was served. That's the, if the notice is served, then this court doesn't have jurisdiction.
Yes, absolutely.
But whether, my lord, this question, my lord, this writ petition is maintainable, any order passed in, my lord, under specified act.
Any order, this is
Oh.
violation of natural justice.
So there is a provision of appeal, my lord. He may prefer the appeal before the authority concerned.
And at the cost of
Jurisdiction of power and authority of tribunal, subject to other provision of the tribunals of such and such.
law.
Any order made by any authority.
That is settled law, the order has to
Lord,
be.
my humble
after
submission
hearing
is
the
that
order.
my
Your lordship pass the necessary order.
I raise the same objection before the
Please,
GLMLR, my lord.
where is your report, sir?
Joseph সেটা বলছে রিপোর্ট চাইছেন Joseph report দিতে হবে
Please show me that you have
Joseph report
got
চাইছেন
or
report
you
দিতে হবে
served
তাতে
notice. That
Joseph report
relates
দিতে হবে
there.
না আমি রিপোর্ট আমরা রিপোর্ট নিয়ে নেবো তো
Please show me the document
Joseph
which
report
served
চাইছে
the petitioner. Then the court will not have jurisdiction. Not before that. Affidavit of service, none appears for the private respondent despite service.
রিপোর্টের জন্য বলবো রিপোর্টটা
তোর উপর
আনেনি রিপোর্ট
There was a direction for report. of
হরিদা
the-
সর্দার হরিদা সর্দার
Counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as intended. Paragraph, let the matter appear under the same heading on 23rd June.
তাহলে সিমিলার ম্যাটার তো হাজার হাজার চলে আসবে
This is an extension. Please file the report on the next day. 23rd June.
23rd June.
Lord, both the next matter, my lord, is also on the same point. Only additional point is, my lord, in this proceeding, I was not even made a
20.
party. There are no question of service notice, my lord, I was not even made a party. A report was called for.
Please appear in the
My lord, my learned friend,
And for the respondent number 5, my lord.
না না কত নম্বর
private respondent.
five, respondent number 5.
Yes, here also, I think a report was called for.
Yes, my lord.
My lord.
Yes, the same order, a report is necessary. The same thing. Whether it was heard.
23rd
23rd. Same order.
June.
এটা affidavit of service দেওয়া আছে
Extension of time.
দিয়েছো জমা
51,
my lord, the affidavit of service in this matter we kept on.
20.
Yes, 20.
Private respondent is appearing.
Yep, my service we kept on.
Let the affidavit of service. 21.
এটা দেখে নিন ভিডিও দিয়ে বলে দাও
Lord, here also, your lordship had called for a report.
It's appearing for the respondent.
I really don't know. Mr. Saurabh Sengupta appeared for the state. Lord, I tell your lordship in short, Lord, all the documents are here. The issue is whether, Lord, a cinema hall contained an excess vacant land under the Urban Land Ceiling Act. Now, Lord, there are several orders which have been passed by this honorable court. Each time, Lord, they passed an order
This one should be there. Absence is. different.
because, Lord, that. Yes.
Yes.
My learned friend
Where is
said-
your report?
কি হয় একটা দিন আগে রিপোর্টটা দিতে কষ্ট হয়
Do you want to come back, Mr. Court?
I really don't know what is there in the report.
Come back after vacation?
Now they want time
Can
to
you put
conclude.
Contact of Mr.
Proceeding has started under section 22.
Shift it to the other side of the vacation.
And this is his handiwork because now he wants three more months. Lord, I think the proceeding started, Lord, sometime
Started and 22nd May is the
2030.
date fixed. Kindly come to page 22 of my report.
proceeding.
And let Mr. Court.
Lord, 22nd May, kindly stay the proceedings until your lordship considers the matter. Because I tell your lordship, there can't be any further proceedings after this last report, Lord, which has come. Your lord, may I just show your lordships couple of, Lord, documents before, Lord, first, Lord, kindly come to page 154.
What is the matter of?
Lord, under the Urban Land Ceiling Act, before the Urban Land Ceiling Act came, Lord, this is a property, this contained, Lord, on Ononna Cinema, this near BT Road. Now, Lord, this original property was owned by one gentleman called Nilmoni Mukherjee and others. There were 3 others. Now, my lord, what had happened is that when the Urban Land Ceiling Act came, they had submitted a declaration, Lord, in terms of Section 6. Then, Lord, a draft notice was issued under Section 8. And, Lord, ultimately, the authority, Lord, found that there was an excess land of 369 odd square meters. And based on that, they passed an order under Section 20 subsection 1 of the Urban Land Ceiling Act, permitting the cinema hall to hold that property. This was challenged by the Mukherjees. They said that the passage of the cinema hall or the car parking space can't be taken as an excess vacant land. So, my lord, they made a representation. Ultimately, the Joint Secretary, my lord, he passed an order. Kindly come to page 196 straight away. Lord, please come to 197, starts at page 196. Around the middle, your lordships will find it says on perusal of office records, it revealed. Has your lordship found that? That the competent authority Barrackpur prepared the draft statement showing 247.12 square meters as the extent of excess vacant land in premises number 208 BT Road. Simultaneously, a prayer for exemption under Section 20 of the Act was also filed before the government, being appropriate authority. The government, after due consideration, has increased the quantum of excess vacant land and granted exemption in respect of 369.79 meters of excess vacant land in the same premises after due intimation to the competent authority. It, however, sounds strange that the owners have not, prior to this review, made any representation before the government disputing quantum of exempted land. The excuse of the transfer of land by the owners of the plea of holding no excess vacant land as presented by the advocate cannot be accepted because of the fact that under Section 5(3) of the Act, no vacant land or part thereof can be transferred till notification on regard to excess vacant land is published. So the owners of the land is transferring the land have obviously violated the provisions of the Act. Then, on going through the entire case record, I hold that the dispute revolves around the actual quantum of excess land. The owners lodged objection accordingly before the competent authority against the draft statement, but the competent authority could not proceed with the said objection because exemption in respect of excess land was granted by the government under 21 of the Act. In order to see that natural justice is not denied to the owners of the land, the competent authority Barrackpur will proceed with the objection petition already filed before him against the draft statement and finalize the extent of excess vacant land in accordance with the provisions of the Act after giving the owners opportunity of hearing. Liberty is also given to the owners to file fresh objection if they desire to do. The competent authority will also cause fresh spot inquiry if required. Now, Lord, this order was passed on 6th of February 2004. And Lord, the spot inquiry was ultimately held, Lord, sometimes in 13th of July, 13 June 2017. Your lordships will kindly come to page 268. There are in between, Lord, there are several orders by the High Court. They passed order which was set aside by the High Court saying that follow the Joint Secretary's order. And Lord, it came up before many courts. There were 3 rounds of litigation. Now, Lord, your lordships may kindly have a look at the report at page 270. I'm sorry.
270.
Yes, but I think it's in the second volume. 270. This spot inquiry was ultimately held, and Lord, this report is forwarded to us on 22nd of September 2017. Your lordships will kindly come to page 271. Lord, kindly take the second paragraph, specification of land area, etc. And then, bhalo copy ache? Oh, kindly, Lord, see the type copy, Lord, at page 270. Please come to Lord 5II, Roman 2. There is no excess land which was purchased by the Canton Commercial because Lord Mukherjees have transferred to us in between. And Lord, there was a order directing Lord us to Lord not to take any steps to demolish. We came up before the High Court. That order was squashed, and then Lord subsequently another order was passed without hearing us. That order was quashed. So Lord, ultimately 272 in 2017, Lord, they come to a conclusion that there is no excess land. Now, Lord, after this, from 2017, nothing, Lord, progressed. And Lord, we have been making representation, your lordships will find from 274 onwards. Lord, we have been asking them to disclose the present status, because if there is no excess vacant land, there is no question of Lord proceeding any further. The matter should end. This is their own inspection report, which we got. Lord, we sought the inquiry report at page 269. Your lordships will find that we asked for the inquiry report, and this was forwarded at page 270. Now, Lord, this is where we are stuck. Therefore, Lord, we have moved the court, and we are before your lordships to say that, Lord, kindly quash the proceedings. Because, Lord, on the face of it, they have found nothing. There is no excess land. That's where it stands.
Now, my lord, we have given the notice, my lord, on 22nd May would be the hearing date. My lord, we will be considering the report of the inquiry done by the competent authority.
What further consideration is
My lord,
required?
that inquiry report is not binding upon the state. The state would be in a position to come up with the objection, because land has been vested. That's how they were granted the exemption initially. So inquiry report is not sacrosanct. They have a right to object. Even state has a right to object towards the inquiry report. Let the hearing be proceeded. Let the authority come to the decision.
But 6 years have gone by. They have
As
woken up.
if they are arguing
Only after
inquiry
your
report is
lordship
everything.
Only after your lordship has asked them to file a report. Lord, this inquiry report they had with them since 2017. Today, Lord, coming up in court in 2023 to say that we want to raise an objection.
Now,
that itself shows, Lord,
now authority has started the proceedings. Let that be concluded first.
How can they start the proceedings? There is no question of starting the proceedings.
Kindly come to the their prayer in the writ petition. The respondent number 3 to disclose the status and or fate of the proceedings initiated under section 22 in respect of the property being number such and such. And throughout their representation, they have made that please let us know what is the status of the proceedings. The respondents and each one of them, particularly the respondent number 3, to dismiss and or drop, if not so done already, the proceedings initiated under section 22. The state has not taken any decision on that section 22 proceedings. Let that be decided.
How long will you take to decide the procedure?
3 months. Only 3 months.
I'll give you 1 month, let the matter remain pending. Come back.
1 month will be
What is
difficult.
the date for hearing?
Then make it 2 months.
Mr. Court?
Lord, kindly don't give them any time, because 6 years they were sleeping. They have woken up from the slumber only because your lordship directed them to file this report. Lord, this is not really, Lord, trying to take advantage of the fact that court is, Lord, giving them an opportunity to come and defend.
Since a date has been fixed, please appear, find out what is happening, come back after vacation.
Very well.
The matter is pending.
Kindly, Lord, place the matter, Lord, immediately after vacation. Because, Lord, your lordship, it's fell from your lordship, kindly don't give them further time. Because, Lord, the intention is very clear, even from the report.
Any time, for the time being, for conclusion of proceedings,
Right.
come back, please tell me the latest status.
And Lord, we will appear without prejudice to our contention that the proceedings can't continue. Kindly, Lord, make it very clear. Your lordship will ultimately decide, because there is nothing more to decide under section 20.
And on that even, they might not appear on 22nd May.
No, we will appear without prejudice.
The report in the form of affidavit submitted on behalf of the third respondent is taken on record.
লোকের প্যাসেজ নিয়ে নিচ্ছিস তোর বাড়িতেও আমি লাগাচ্ছি না বাড়ির প্যাসেজটা আমি বলবো
Review of the report. Submitted before the subdivisional officer, Director, North 24 Parganas on 30th June 2017. Indicating that there is no excess land that was purchased by the Canton Commercial, the proceeding under Section 22 of the Urban Land within bracket Ceiling and Regulation bracket Closed Act 1976 has become redundant. Paragraph. Learned counsel for the respondents submits that
It doesn't survive, actually.
hearing has been fixed by the competent authority in regard to the proceeding under Section 22 of the Act of 1976 on 22nd May 2023. Stop. The petitioners seek to appear before the authority.
I'm sorry to but one more, that inquiry report is not sacrosanct and that is not binding upon the state. And that I have also submitted.
Okay, the learned counsel further submits just last sentence that the report submitted before the subdivisional officer is not sacrosanct.
But my submission,
Not binding upon the.
but this is what I dispute. I say for 6 years, this inquiry report has not been challenged. So Lord, kindly record that and our declaration that we have sought based on that.
In disputing the submission made on behalf of the respondents, learned counsel for the petitioner submits that the inquiry report has not been challenged by the authority since 2017. Paragraph, be that as it may, since a date of hearing has been fixed by the respondents on 22nd May 2023, the petitioners are at liberty to appear before the authority on the said date without prejudice to their rights and contentions. Paragraph, let the matter appear under the same heading for further consideration. On 14 June.
14th. But will appear Lord without prejudice.
I record.
Much older.
Declare.
I appear for the writ petitioner. This relates to that tender of
52.
the airport golf cart. Now, pursuant to my lord's direction, I had implemented the tendering authority, which is GEM, as a party, because the airport authority said that they would be the best person to answer. But they have appeared, they have filed an opposition.
You are appearing?
I am for the.
They have filed an opposition, I have drafted a reply to that, I need.
Opposition,
Yes.
It was report.
Yes, it's a report was called for, I have drafted a reply to this report because I have to deal with this. It's ready with me, I need only 1 day's time to affirm and serve, I want to come on the reopening day, I don't want to delay it, I just want, yes, I'll serve it on Friday. I'm enjoying an interim order, but
Interim order.
yes, this was, it was extended from time to time and then made absolute because of the prima facie case that I was able to make out, But I do not want to delay it, I want to come up on the very first opportunity.
Serve this affidavit as long as back as 2nd of May. And today is 15th of May. Your lordship fixed the matter on 15th of May.
considering the urgency. Your lordship intended to dispose of this matter before my lord vacation. And my lord, only another thing, my lord.
As far as I can recall, there is no interim order. I think the authority
Your
has
lord-
extended.
Yes, and I am till 30th of June. I'm doing it till 30th.
Your
of June.
lordship, the extension is not merely 30th of June. It reads as if anything happens, if the authorities come to the conclusion before that, then the contract ends with the writ petitioner. Now, your lordship, the services which are being provided is with regard to the golf carts, and that's an emergency service. And there, the writ petitioner cannot take advantage of this by delaying the whole proceeding. I am appearing for the airport authority, your lordship, respondent
may I-
1, 2,
may I
3.
just
The
respond to
writ
this?
petitioner cannot.
Yeah, my lord, this is for the first time that I'm asking for an accommodation in this
Your
matter
lordship,
throughout, my lord. And I don't want to
will
delay
not
it,
take
my
the
lord.
time,
I'll
your
serve it
lordship.
on Friday, and this can be
They
heard on the
cannot-
opening day, my lord.
Your
I have no
lordship,
problem.
this cannot be delayed. In any event, we have given the report at the, in any event, we have given the report that there was no technical glitch.
Yes, that's
There
your
were
stand.
many participants at that period, at point of time.
Reason why the.
Yes, in any event, there are disputed facts, your lordship. Now, if at the same time, which the writ petitioner is claiming that there was technical problem and they could not participate, and when I'm showing that there were participants who have submitted and uploaded their bids at such very point of time.
Separate report was called for.
Yes, your lordship. Now, your lordship, it has to be, your lordship, then kindly disposes it of before vacation.
Subject to your lordship's correction, my lord. What I find from this writ petition, my lord, this my lord pertains to group 9, my lord. Please, my lord, subject to your correction, my lord, I do not think, my lord, your lordship.
This
my lord,
point was raised at first instance,
No, I
my
have-
lord.
I have not-
Yes, it was raised. My lord had
I've never
considered this.
This is my lord, first time I am, my lord, raising, my lord.
Because it's a tender matter.
Okay, it's a tender matter, my lord, honorable justice, motion be what to get this, having the determination, and my lord, your lordship is aware that there is a division bench. judgment,
Transport-
any order passed, any order
Transport,
passed-
my lord.
It is, my lord, not transport, my lord.
This is not transport.
Any order, my lord, passed in absence of the.
Then I'll-
My lord,
My lord, no, in that event, my lord, let me examine this, my lord. And may I come back on Friday if my lord does not have determination, my lord. In that event, my lord will release it and relegate it to the bench by having determination.
Not today only. Please
But
come back
tomorrow I'm not in some difficulty, my lord. On Friday, my lord, kindly keeps it on Friday. I shall come back on Friday.
Friday.
And on this aspect, my lord,
It used to be also that
I shall also check this, my lord. If he says, my lord, well, I'll check this.
Then,
Let
your
it be on Friday.
Your lordship,
It is my lord, purely one of tender matter.
Very well, my lord. Let
Your
it be on Friday.
in that event, your lordship would be pleased to keep it as to be mentioned, your lordship, because in any event, whether it will be released or
No
not.
problem. Friday to be mentioned, my lord. No problem.
It is submitted on behalf of the respondents. That since the matter relates to issuance of tender, this court has no determination to deal with it. Paragraph. Learned counsel for the petitioner seeks accommodation. Seeks at accommodation. Paragraph. Let the matter appear under the heading to be mentioned.
Correct. You're right. You're absolutely right.
19.
Friday, my lord. I shall come back.
No, no, it will go.
23.
I beg to appear on behalf of the petitioner. My lord, petitioner, my lord, petitioner granted lease in the year 2018 on 28th of March 2018, my lord, for lease for extraction of the sand, my lord. Now, my lord, from the inception of business, petitioner was intercepted by the local rules. If your lordship will kindly see page 17 once, my lord. This is the report the BLRO made before to the inspector in charge.
Yes.
Lordship sees that. Now, my lord will kindly see thereafter also it was not stopped. Subsequently, petitioner made several representations. Now, you will also kindly take table to look at page 19. See, the ADM borrow on is requested to the ADM
for joint demarcation. Because the illegal extractor, my lord, by using the another way, they are extracting sand from us. Now, my lord, ultimately that was done. Now, in the meantime, my lord, my lease period was expired. Prior to that, I have made a representation before the authority. That is at page now 47. Now, prior to that, if your lordship kindly see page 25 once, my lord. This is regarding now on page 27. This was a newspaper also. It was published in the newspaper regarding this illegal extraction. Page 26, 27, 28 onwards, my lord. Now, my lord, I have made a representation before the. Page 47, my lord, to the ADM, I have made a representation for extension of the lease. Twofold grounds, one COVID and another this is the now judgment.
Yes.
Now, my lord, see, state has admitted that due to therefore they cannot provide me the free and fair environment for the business. For that purpose, I, as well as for the COVID, I made a representation. Let the state be directed to consider this my humble prayer. In the meantime, not to take any third party steps. This is my humble prayer because it's an admitted position. State could not provide me the free and fair.
No. Logically, look to page 47. What is it? Not you lordship kindly see page 47 is representation. His lease period is already over. He wants extension. And what is in the representation? You lordship kindly see. II, page 47, II, Roman 2. After passing few days, I found some persons in the locality illegally extracted sand from my allocated area. Then your lordship kindly come to page 48, Roman 5. That illegal extraction was stopped for few days, but again, one person, namely such and such, who is also lazy, not collusion with it, Abdul Mullah Samson caused extraction. So his grievances against the police, I mean, some persons who are illegally extracting sand. So he has gone to the police station. Police will take the action if his lease period is still existing. His lease period has gone.
Your admission also. You have also written to the police, not the petitioner.
Right, that page 4, you logically come to see page 4, pleading, he has written. Paragraph 5, page 4 from the skipping.
The document.
Your lordship kindly see in the pleading also he has written.
Yes.
Page 4, not skipping 4 lines. So not whether his lease deed is existing or not. His lease deed period is already over on February 2023. He wants extraction in the guise of somebody is extracting or illegally extracting him. Can it be allowed?
Sir, that it has been done illegally.
Not, now he has written many things. He has written that COVID period. COVID is not a force measure. It is one of the things. Your lordship knows it. No, he has not stated. Many cases I have done. Most of the petitioners coming with the in the representation he has written. Your lordship can see. That is para, your lordship can see para 7, page 48. In the meantime, COVID-19 was spread over throughout the world. Entire business was closed during the period of government imposed such and such.
Yes.
No, but the COVID is not a force measure.
COVID is not force measure.
No, it's not a force measure. I will show your lordship in earlier cases also I have argued before my lord.
My lord has seen this
তুমি যখন বলেছি একটা কথা বলিনি আমি।
Can be force measure if not.
Not in this case, his representation can. This is my humble submission before my lord. It is exactly his. There is no provision in 2016 rule for extension of lease. Merely extracting, somebody is extracting illegally. Sandmans, it's
Have you taken from the state of
that police report will come forward with the police report. What action has been taken? But whether lease is still existing, it is not existing. Lease period is over. Lease period is over 23 February.
Ganguly, he wouldn't have come to the court if the lease period was existing. He has come only because it has expired.
But causes, what have been stated in the representation?
Valid causes.
Lord, I believe these are not the valid.
Prior to experiment.
COVID-19, somebody is illegally extracting.
See, as on that I have no role in the matter. After the expiry of this, the area or the mining lease would be handed over to mineral development, then it would be auction. It is during the existence period of the lease, that is between the state and the petitioner, the lessor and the lessee. If any dispute arises, that is to be decided by the lessor.
Let the representation be considered within a
So see, the
stipulated
state
time
will,
frame
it is for the state to.
and no step be taken by the authority during pendency of the representation.
Not if the lease period is over still, even then.
Yes, because these are very valid grounds. And the lease deed contemplates extension.
My lord,
The lease deed contemplates extension of the lease under certain valid condition for valid.
Part 4.
And it is absolutely the inaction of the state authority that he has been unable to start mining operation. No step has been taken by the state. The petitioner was, you cannot say we do not know, you are representing the police also in this matter. Yes?
Whether the illegal acceptance in action, those are not on the court. Those things have to be unpicked for my court. Those, they are also not made part.
Mr. Ganguly, you are appearing for all the respondents?
No, I am not appearing, but.
You are not appearing.
No, Lord, I am appearing for.
The state includes the police?
No, Lord,
Is that all?
police is not made a part.
Is the duty of the state over only by information?
Action of police. This is not, police is a part.
It is inaction on the part of the state, not the police. Or learned counsels for the parties. The petitioner was granted long-term mining lease for a period of 5 years. V-Day deed of lease dated
28th of March 2018. my lord.
28th March 2018. This has expired on 27th March 2023. Stop. The petitioner was unable to commence mining operation resistance offered by local people, which was informed to the authorities. So, a joint raid program was held by the concerned authority on 13th December 2018. And in a letter issued by the Block Land and Land Reforms Officer, Mongol Court, Purva Bardhaman, on 14th December 2018, to the Inspector in Charge, Bolpur, Birbhum, it was stated that the local people were extracting sand regularly from the sand block in question and were threatening the employees of the lessee / petitioner hearing and forcibly extracting sand from the leasehold area. The petitioner was unable to commence / carry on mining operation, also due to advent of the COVID-19 pandemic. Stop. The petitioner submitted a representation before the concerned authority on 15th February 2023, requesting extension of the lease period, which is yet to be, which is yet to be considered. The petitioner prays for a direction from the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents, for the state respondents, has not been able to produce any document to indicate that necessary steps were taken by the state respondents / lessors against the illegal mining operation undertaken by the local people, or in order to enable the petitioner to commence mining operation in the leasehold plot. Stop. Paragraph. Since the representation submitted by the petitioner is pending consideration by the authority, comma, the writ petition is disposed of, directing the both respondent to consider and dispose of the representation dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, and in the light of the observation made in this order, comma, in accordance with law.
But in the meantime,
The decision taken by the authority shall be communicated to the petitioner within a week thereof.
in the meantime, not to take anything.
Within a week thereof. Paragraph. Pending disposal of the representation, and no coercive steps be taken by the concerned authority against the petitioner in respect of the plot in question.
Get.
Disposed of which.
In this matter, my lord, on behalf of Mr. Tapan Datta Gupta, I am praying for not today, my lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 23rd June.
I am not suffering without what happened without second time.
তপন দা আসতে পারেনি, বয়স হয়েছে তো।
What happened without
তপন দত্ত তো পাচ্ছে না।
on my instance,
On the opening date fixed, my lord, I will inform.
আপনার they are not without neither without proceeding with the active not.
Very well. Come back on 13th June.
Get.
13th June. 13th June. 25.
Petition was directed against Millard a notification saying that Millard my property Millard comes under the definition of enemy property. Millard on the last occasion, my lord's Millard pleasure was Millard to direct the central government to Millard use a report. Millard a report Millard we have been favored with a copy of the report, which is Millard less of a report, more of a fairy tale. Millard I would Millard like to use Millard an exception Millard to this report.
Let it come.
After vacation.
তার আগে পারবো না স্যার।
Report in the form of affidavit submitted on behalf of the respondents.
The report says Millard asks Millard to Millard treats us as Chinese people. That's why Millard I said Millard
Kindly also keep
less of
the
a fairy tale.
question of maintainability of the reputation, because section 18 of
But
the
I have an
Act
answer to-
provides that whatever decision has been taken and vested to the custodian is revisable before the settled government.
Millard I have an answer here and now Millard kindly
No,
keep
but
it
there is a
open.
judgment I shall produce on the next date. Kindly
Second on
Kindly-
record. Learned
Notification.
counsel for the petitioners seeks to use an exception to the report. Paragraph. Let the matter appear under the same heading on 23rd June.
Yes, Millard. Great.
Paragraph. The issue of maintainability is kept
the Panchayat authorities, my lord, had reached out to me, my lord, wanting to formalize that particular relationship because I was in occupation. They wanted rent out of the entire exercise. Now, my lord, I was asked to, my lord, make over a formal application. I had taken out that formal application, my lord. Eventually, my lord, the land under 49, my lord, stood.
It is the Panchayat authority.
My lord, I have, my
you
lord.
served?
I have, my lord. All of them, my lord, have been served.
Ram Pradhan, where are they?
My lord, all of them have been served, my lord.
Yes, sir.
They have served, my lord. Well, the Panchayat comes a little later. By this point of time, it is the land reforms officers who are the persons concerned. There was. The state, my lord,
Yes.
Now, my lord, the land and land reforms officers at that point of time wanted to settle it in my favor. I take out a formal application, my lord. That application, my lord, stood consequently allowed, and the BLRO settled it. The issue was with regards to the drawing up of the deed. Drawing up of the deed for the long-term lease. My lord, Selami and the rentals, which all of that is, my lord, stipulated. Now, my lord, suddenly during the interregnum, my lord, the Panchayat issued I was not aware, of course. The Panchayat started construction on that particular plot of land. And while I reach out to the Panchayat authorities, at that point of time, I come to know, my lord, that the Panchayat apparently has issued, my lord, a tender for the purposes of constructing a plastic and solid waste management plant. My lord, a plastic and solid waste management plant just beside my facility where I produce consumables. Now, while I reach out to them, I tell them that, look here, this area, my lord, this area, my lord, there are a number of vested lands. Now, while I reach out to them, I show them their record of rights, and I indicate that there are similar other lands where you can take this facility. You don't have to do it just beside my facility where I'm producing. Now, my lord, that of course has not been considered. My lord, I have twofold prayers before your lordship, my lord. Principally, my lord, the sewage waste management plant facility which is there, my lord, that has to go. That is not in consonance with environmental laws. That is not in consonance, my lord, with any of my rights, my lord, which has been protected under the constitution or with regards to, my lord, employment, my lord, and the second portion is with regards to the lease, my lord. My lord, I was in occupation. I had, my lord, invested a substantial amount of monies, my lord, construction of the roads and other facilities, my lord. I gainfully employ, my lord, residents of that particular.
That portion of
Not anymore, because, my lord, I have been, my lord, thrown out of there, my lord, and
How we can occupy?
lord, I was in occupation, my lord. That is their admitted
That
documents.
is our land. How we can occupy? No, you can't occupy that land.
Well,
He made for an application for long-term use, but that he can't use that land without getting that.
He has made an application.
Not just application, it's been declared, page
Page
58.
50.
Page 50.
It's declared.
Just regional number.
Yes, 51A.
Yes.
Settled.
And have a look at section 49(5). So my learned senior friend submission is not correct at all. If this is the order and this is not under challenge, my lord, subject to what my learned senior friend says, it's my land.
You're asking for implementation of this.
Yes,
order.
absolutely. And if this order stands, my lord, nobody else can even trample upon my land, especially the state. হ্যাঁ করতে পারছো না আচ্ছা না রে আছে টাইপ কপি আছে দাদা
It's typed copy.
টাইপ কপি 51A তে
this is strange, page 52.
My lord.
This is 13th November 2015.
Yes, my lord.
They propose an interdepartmental transfer
Yes, my lord.
for solid waste management schemes.
Yes,
And then after that, they allot the land in your favor,
yes,
December.
my lord. That's their conscious decision.
Not in this matter, my lord, I must give the report in the form of evidence, because
Very well.
otherwise.
Then kindly stays any sort of, my lord, construction any further. Any sort of construction. The state can't, my lord, go on.
Am I present of the repetition?
My lord, kindly stays it. Because if I have made out a prima facie case, my lord, I am entitled to an injunction. 83 Supreme Court. Entitled. If they will not do whatever they have to do it with it, I don't, my lord, solid management. But they will not commission it, and all the ash and everything will go into my rice mill.
So they please come back with a report. And no construction till disposal.
In such disposal, my lord, that is the
Yes.
limited period, my lord, your lordship can pass the.
Lord, I'm extremely sorry. I tried my level best to get in touch with your lordship, Lord, but the constraints between this side and that side, I couldn't. Kindly accept, Lord, my no words would ever, my lord, console my lord, but then your lordship knows what I'm going through. It's a everyday process. So I understand, my lord, that agony that my lord goes through.
One who
Please.
goes through it realizes.
I realize this.
You-
I-
Thank you for your concern.
May I have my lord's kind leave?
Discontented. Heard learned counsels for the parties.
এগুলো কি করে লং টার্ম লিজ দিল তোমাকে যা চলছে
It appears from
একেবারে ইলিগাল
the order of the Block Land and Land Reforms Officer, Katwa 1, normal one, Arab one, passed on 16th December 2015. That plot of land in question, P plot number 988, comprising an area of 0.03 acres.
30 acres, my lord.
0.30 acres, sorry, of Moja Mondol Hat, comma, jail number 24. Was proposed to be settled on long-term basis in favor of the petitioner for using the same as ash pond purpose. ASH, ash. Ash, ash pond purpose, short small letters. Surprisingly, comma, by a letter issued on 30th November 2015, comma, the additional district magistrate and district land and land reforms officer Bird 1 directed handing over possession of the same plot in favor of the Panchayat and Rural Development Department, comma, Government of West Bengal for solid waste management schemes. Solid waste management schemes. Stop. Such contradictory stand taken by the state respondents is assailed in the petition. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 19th June. Paragraph. no further step be taken in respect of the plot in question. Status quo construction is going on. Status quo would.
Would mean that continue.
Construction.
যে অবস্থায় আছে সেই অবস্থায় থেকে যাবে।
Construction is going on. Status quo means construction will continue.
Continue.
Status quo is a very dangerous order. No further step including raising construction be taken in respect of the plot in question by the state respondents till 30th June. 30th June.
So very good.
30th.
30th?
19 তারিখ আসবে। 19 তারিখ আসবে। 30th of the interim.
ও ইন্টারি বটে।
Thanks.
আমরা কত রয়ে
28.
My lord, I appear for the Union of India.
I appear for the petitioner.
28 না তো
28. 28 to 41.
Yes, 28 to 41. My lord, this leads to, my lord, the expansion of the third line in the Noida district. So, my lord, this there is an acquisition which is being made by the Union of India through the railways, and this is a very, my lord, prestigious project for expansion on that side of the country. Now, my lord, there is an acquisition being made to which there is a dispute which is arisen. So there was a, my lord, joint inspection committee which was framed. Now, my lord, the joint original report has not come before my lords. There was a direction on the state to file it, but somehow it is not there, but a copy has come. My lord, we are to take an exception to it because, my lord, as per our records right up from the, my lord, British era, these lands seem to be, my lord, belonging to us, which has not been considered. So obviously, no, I am appearing for the Union of India. Petitioner is the landowners. Now, my lord, we have to file an exception to that report. So, my lord, I understand
Filed by?
this is a joint report. Yes. Now, my lord, may I just complete, my lord? So I have to file, my lord, a exception to the report, which, my lord, I believe there was a direction given, but I need a little, my lord, extension because, my lord, there is voluminous report, my lord, records which I have to rely upon. And this is an hearing matter, my lord. Of course, lordship has to hear us out after that. So if your lordship keeps it after the vacation, my lord, I can file the exception.
Motion stage, why?
Yes, I can, my lord, lordship can keep it in the motion only after the vacation. I will,
Exception, I'll deal with it.
yes, yes.
Yes.
If the report they want to exception, file an exception, my lord, the fresh report is to be filed.
No, no.
Report is already.
If lordship feels,
My lord, if not letter.
On the original petition, there was a liberty to use exception.
yes.
He's asking for extension of.
If lordship considers there is a fresh report to be filed, then lordship will direct.
Lordship, the report is there.
Originally, my lord, initially state filed a report, my lord.
Yes.
We wanted to file an exception. Your lordship directed to make joint inspection over the plot. Your lordship directed. Then the state authority as well as the rail authority made joint inspection on 25th November 2021, pursuant to lordship's direction. 8th December 2021, joint inspection was held.
To which we want to
Yes.
file an exception.
So after that, this report has been handed over by the state as
No original has been filed in court. Although there was a direction for
it is a
on the
joint
state.
inspection report. Then
এ কি দেখছিস? এইরকম?
So will you come back with the report first?
Yes, my lord.
Very well.
If he wants to give exception, my lord.
I have a copy. I will in the meantime give the exception also.
Wanted to file an exception, my lord.
Yeah, let
That
him.
is, he did not realize this, my lord.
But there is no report on record, Mr. Dev.
I mean, I am not on that point. I can file the report, my lord. I shall file the report.
My
But
lord.
he wants to, my lord, the
Use-
legality,
yes.
my lord, he wants to go in legality of that.
Yes, yes.
That is the
Yes, I'm
Railway
saying.
My lord,
wants to file the exception with regard to this
My
joint
lord,
inspection.
I believe, my lord, I'll clear the doubt. I believe the original which my learned friend will file would be the same as this one. I'll go by it, by his words. So, my lord, I will also prepare the report in the meantime so that the matter is heard out expeditiously and will come back.
Come on the next occasion.
Yes, and we'll file the exception to that also. তাহলে তাড়াতাড়ি হয়ে যাবে একবারে।
Learned counsel for the state respondents.
উনি বলছেন
Seeks
original document টা
extension of time to submit the report in the form of affidavit as intended. Paragraph, let the matter appear under the same heading on 26th June.
My lord, only thing, my lord, kindly directs that exception also because union is there, my lord, otherwise they are so lackadaisical, they'll not, my lord, proceed.
আচ্ছা, ওটার একটা line add করুন। On prayer of the petitioner and the Union of India, comma, liberty is granted to use an exception to the report, comma, if required. Paragraph, let the matter appear under the same heading on 26th June.
Very well. Only one thing, my lord, as Mr. Chatterjee said, my lord, is due to the constraint, I also couldn't reach out, my lord, accept my condolences. I understand, my lord, it's a very hard time. Grateful.
কোথায় order?
আছে ওই তো ওইটাতে।
Group 7 application 193.
My lord, I appear, my lord, for the petition in this matter. My lord, this is an application for restoration. My lord, I have served copies. My lord, the affidavits of service. My lord, my lord, on the last occasion, my lord, according to the records, my lord, Mr. Shoptoshi Rai was appearing at the time. He's, my lord, I understand no longer. My lord, I have received a letter from the railways that, my lord, no, he was then, my lord. I have received a letter from, my lord, that, my lord, Miss Srimati Chandri Alam, senior counsel, my lord, she would be appearing in this case, but, my lord, I am submitting the affidavit of service.
Is it served?
My lord, it has been served.
Let there be a date for the petition.
My lord,
Is it within time?
Short-
Within time?
it is, my lord, to my knowledge, my lord, so far as, my lord, this was dismissed, my lord, during 9th of September 2021. My lord, I was, my lord, under, my lord, post-COVID symptoms. My lord, I had suffered COVID. I have annexed the RT-PCR report, as well as, my lord, some of the prescriptions. My lord, also, my lord, there is one point, my lord, I want to, my lord, indicate to your lordship. My lord, kindly takes page 13 of the application.
Let them appear.
My lord, because this matter, my lord, was directed to go out of list. My lord, it was adjourned sine die, my lord, with an SLP pending before the Supreme Court. Once it is disposed of, till 2 weeks thereafter. My lord, that order is, my lord, at page 13 of this application. Lordship kindly, my lord, takes for a moment. My lord, I am reading, my lord. My lord, I am reading the last paragraph. In view of the such submission from the bar, let the writ application go out of list with liberty to mention when SLP will be disposed of by the Supreme Court. Since the writ application has not been taken up for hearing by this court till date, the interim order passed by this court in connection with the said writ application is extended till expiry of 2 weeks after disposal. My lord, my respectful submission, my lord, that has not happened. So, my lord, I was under the bona fide impression. It is still pending, still pending, still pending. So, my lord,
Restore it and let there be a, there's no question of a date of hearing because it's still pending. So
my lord.
let it go out of this.
Lord, I am led by Mr. Kaur.
Let it go out of this for the time.
Next letter is same.
Yes.
I'm bolo. Affidavit to the.
Affidavit of service. WP Theoretically. In view of the order passed on 24th August 2017, let the matter go out of list.
My lord, let it be restored to the file and number.
Yes.
My lordship is restoring it to the file and number.
Yes.
My lord.
And
My
the
lord.
writ petition will be out of list.
My lord, I am led by Mr. Toro. He was just here. My lord, I am giving his name as well. And Didi, call. My lord, the next matter is identical.
194, sir.
My lord, I have served. This is the affidavit of service.
Also SLP is pending.
Same, my lord. Same order. Lordship will find at page 13. That similar order on the same date.
The order is on the same day.
Yes, my lord. My lord, even the dismissal order on the same date, even the that extension order was also on the same date. My lord, at page 13, 24th August 2017. No.
24th August 2017.
I'm grateful to your lordship. Didi.
Hmm.
195.
I'm appearing for the petition.
Yes.
I'm appearing for this.
Lordship, I'm for respondent number 5 and 6, Your Lordship. Your Lordship, their application for counter signature is pending before respondent number 5 and 6. I've got instruction that the meeting was going to be held of the STA was going to be held today, Your Lordship. But due to some reason, it has been adjourned to 24th. Lordship.
24th of June.
20, no, May, Your Lordship.
So let it be adjourned for some time.
Lordship, after vacation, Your Lordship, till then the decision will.
It is submitted on behalf of the 4th and 5th,
Fifth and
you're the
sixth.
5th and 6th,
Five
the
and
5th and 6th respondents, that the meeting of the board for consideration of the application submitted on behalf by the petitioner is scheduled to be held on 24th May 2020. Paragraph in view of the above, let the matter appear under the same heading on 14th June. Lordship. Please come back with the decision taken in that.
Lordship, I'll-
It's 196. 196.
I am for the private respondent.
Now, my lord, this matter, your lordships. On the last occasions, your lordship was pleased to ask me to serve a copy upon the private respondents and my lord, it is my lord, between the, this is in between the my lord, uterine brothers. My lord, it has been transferred. My lord, the permit which has been transferred in the name of the petitioners. My lord, by the STA. Upon giving an opportunity of hearing both the my lord, petitioners and the my lord, transferor and the transferee. But the resolutions which they adopted, that has not been given effect to till date. Although the resolution is there, the lordship will find at page 21.
The private respondent has transferred in favor of the petitioner.
My lord, they are the uterine brothers, my lord, they have been, and the hearing was taken place. And both the transferor and the transferee appeared before the STA. The decisions adopted in favor of the transfer, and but the transfer has not yet been given effect to, but till date. Now, the one part is this. Now, that in the meantime, the vehicle intend to, the transferee. He intend to replace the vehicle which is there in the permit. Now, both thing is still pending, and either the and in between these, I think renewal. That is going to, that has already been expired because transfers in record of the STA has been done. The actual transfer in the permit has not yet been. So that's why neither the renewal nor the replacement can be possible by the petitioners until and unless it has been endorsed in the permit itself. So that is only prayer. And there joint applications is there also, my lord. Your lordship will find at page 25. There again, my lord, the transferor and transferee.
This is the petitioner.
My lord, my lord.
So let this be considered in the light of the observation.
My lord, only this prayer.
My instruction, my lord, it will be not transferred because now you can turn to page 24.
24.
Whose signature is there? As yet not been transferred. Manjit Singh. Madam person.
Yes.
Application for Garmel Singh. Garmel Singh is the original permit holder.
Yes, transfer.
This business should be dismissed, my lord.
Okay.
Cannot be because
No, your lordship can't.
till date he is not the transferor. He is not the owner of the permit holder. How can it be? He applied for renewal.
Page 21, you have.
24, page 24.
That comes later on. Page 21, you have approved the transfer.
Yes, this
So
is
it was
lordship
your-
policy.
Yes.
Recommended transfer of permit, yes.
So it was your
Recommended.
responsibility.
Recommended, but he has not been provide any paper till my lord. He has not.
Next page, we have jointly
1st
applied.
November 2022. 1st November 22. Manjit Singh failed to get the permit transfer in his name within the stipulated time fixed by the STA board. That is within 1st November 2022. And also praying for producer vehicle register number complaint that is not accepted as per the STA board.
They wanted to submit a report in the form of an affidavit. Mr. Mukherjee, let him come back. He is saying now BSc because the prevalent pollution norms also have to be complied.
Now, my lord, only one thing, my lord, let him come with the proper report, but the thing, your lordship, kindly see the route, which is outside the cave completely. It is an interstate route, my lord, from Aksha, that is in Odisha, and up to Asansol. Your lordship will find the Aksha to Asansol. This is outside the KMA area. That you let him place the report. I am not on that.
Oh, no question of PMA. PS norm has to be followed. PS3 ne.
This is in respect of KMA. The last two occasions, your lordships observed the Supreme Court as well as my lord. That in respect, yes, my lord. That in respect of the KMA.
The for implementation of the resolution taken by the state respondents in their meeting held on 17th March 2017. Paragraph Learned Counsel for the state respondents seeks to submit a report in the form of paragraph 15 June.
15 June.
15th June.
Can it be prior to it?
The previous week we are reopening.
Oh, 5th is reopening. No,
197.
May I please, your lordship? I am for private respondent number 6.
I am appearing on behalf of the petitioner.
Yes.
I filed up about the copy of the respondents.
Yes.
Well, I served the copy of the private respondent, my land is appearing on behalf of the.
Yes, yes. I am private respondent number 6.
Well, here in this case, my lord. Well, kindly see the page number 16. The private respondent 6 man holding a permit.
Page number?
Yeah, page number 16.
68.
16, page number 16.
Yes.
These permits are holding by the petitioner. Now can you see the page number 18. At the bottom left side, at the bottom left side, page number 18 at the bottom left side.
16 is the petitioner's permit.
Yeah, permit was transferred in the name of the private respondent. On my lord, 19th July 2018, from that date, my lord, he is the permit holder.
Petitioner is Ravindranath Das.
Yeah, Ravindranath.
And page 16 says.
16, my lord, the private respondent.
Yes.
Private respondent. What did I miss say?
Josh.
Yeah, probably just private respondent.
16.
Page number 18. No, page number 18 at the bottom. This one.
Someone else, a third person.
Yes, please.
Srimati Sriti,
No. The letter of permit transfer, page number 18. Page number 18.
You are referring to 16, sir.
Yes.
Say page number 16.
16, malo, originally permit was issued in the name of Shanti Queen. Later on, page number 18 at the bottom left side, the permit was transferred in the name of Gopal Jas, private response. At present, my lord, private response 6 is the permit holder. Now, my lord, the private response 6, my lord, approached my lord the petitioner to sell his vehicle. And this vehicle is covered in this permit. So, my lord, as per agreement, sale agreement, the vehicle was handed over along with the permit. Now, my lord, joint application has been made by the petitioner and also as well as the private respondent for transfer of ownership of the vehicle as well as for transfer of permit. Page number 20. Page number 20.
Yes.
Yes. This is the joint application. And my lord, with this application, my lord, agreement, sale agreement, page number 22. And also, my lord, again, the my lord, joint application for transfer ownership of the permit and also vehicle. Both, my lord, petitioner as well as private respondent, along with all the documents, page number 26, one number 29, 30, whatever, my lord, permit is required to be complied, that we have complied. So after compliance, all the formalities, now, my lord, Secretary of Transport Authority, can see the page number 41.
41. Yes.
41.
Yes.
Secretary Regional Transport Purva Bardhaman, filed memo dated
10th March 2023, call the petitioner as well as the private respondents for hearing
Yes,
on to be held on 27th March 2023.
yes.
Yes. Next page, this is the resolution. Page number 42. A resolution of RTA board meeting dated 27 March 2023. Serial number 11. Gopal Josh name also can be recorded. And my lord, remark, resolution. The transferor and the transferee did not appear in the verification process since the prayer for transfer of property is thereby rejected. None appears. Now, why I could not appear on the day that I disclosed, my lord, page number 44. So I made a representation why I came to know that the matter was placed before the board meeting.
Objection.
And also application rejected on the ground of because none appears on behalf of the also none appears means transfer at both transfer did not appear. But on in between, my lord, 20th March and 3rd April 2023, I was on two program because long prior to that, I met the two program. I have imposed all the tickets, air tickets and also plane tickets. That the ticket was booked on 5th February, 5th December 2022. And my lord, two program, my lord, I come back next page. 2nd March 2023, I came back to New Delhi on the day from 2nd April, 3rd April. 3rd April, I came to Bardhaman. But during this period, while I was out of station. So I made a representation requesting authority to place the matter next board meeting to take a fresh decision upon shift. Because the decision rejected only without any value due to absence of date. So kindly set aside this resolution, page number 42, direct the authority to consider my representation for transfer after hearing both parties. These are another's.
Revisit the,
Repeat.
revisit the.
It's not on merits.
After
They
hearing
did not appear, it was.
My lord, there's something I want to submit for your lordship. My lord, I am the private respondent. I happen to be the actual owner of the vehicle. At the same time, the authorization. My lord, I have already made a representation before the Secretary RTA, whereby I have vehemently objected to the contention of the application, because the main thing that when the agreement was entered into, the signatories, particularly my client, was not in good shape. He was suffering from various kinds of ailments. Various kinds of ailments. And my lord, the second thing is this: in the petition, so far as the law of the this authorization is concerned, it cannot be transferred for in lieu of money. That is the most important thing. Here in the agreement, it has been categorically stated the amount that was given was the consideration of the vehicle, but not about the authorization. And that is being the reason I have vehemently objected. When I recovered from my ailment, I recovered and I immediately drawn the attention of the concerned authority, whereby I have been made it crystal clear that I am not willing to hand over the authorization to the petitioner. My lord, this is my innocuous submission before your lordship. As per my stance and my instruction from my client is concerned, even today, I have been instructed that he is not desirous to hand over the authorization.
Your objection is pending before the authority?
Yes, your lordship. My lord, this is.
He closed all the documents. The Lord private respondent himself that it's a signature. He made a joint petition has been made for transfer ownership, transfer both, because he has already taken entire amount and everything examined after examining all these documents, including these documents. Authority take decision.
My lord, there is something going on between the lines. The thing is this. I have requested the petitioner I am willing to have return the money if required. And my lord, he has not shown any inclination to accept the same. And taking the advantage of the situation, now he has approached with the writ court so as to put pressure upon me to hand over the authorization. My lord, here, though it is in a rough format, I am supposed to be done in the form of an affidavit, but this is my objection.
He has himself submitted documents.
I have changed my mind, and that is being the reason I have made an authorization.
Development.
Yes, your lordship.
So what do you say?
My lord, I have annexed all these documents. These are agreement. He has in taking the entire amount. Thereafter, he met the representation before this.
At best, he can
return your amount, refund your amount.
Yes.
He wants to refund the amount paid by you He is not willing to part with the vehicle.
He says so before the authority because he himself requested the secretary to transfer of the ownership of a transfer of ownership. Now, my lord, at the bilateral stages, at these stages, because after long, because that's the this document was submitted not long back. Therefore, they had no connection with me.
There is nothing further to be adjudicated in the writ petition at all, sir. The writ court would have intervened only when your application would be reconsidered.
Yes.
But one of the joint applicants is the private respondent.
Yes, a private respondent.
He is residing.
I'm withdrawing myself.
Earlier stand.
So what is the he just before the authority will take decision.
The writ
Because
court
this
cannot-
that copy has not. I'm not aware of these documents.
How can the authority take decision? It is his. vehicle.
I am
He doesn't have to
submitting my
handle it.
appearance. I'm making the submission before this honorable court. I'm representing my client. What more you require?
Because my lord, as per agreement, he has the documents. He has also joined as per section 1, rule 115 provides that. But if in case of transfer ownership of the vehicle and transfer of the permit, joint application will be made. I made the joint application. Now he will express that before the authority that now I submit his fact that I have submitted the application for transfer ownership in favor of the petitioner. Now I say we'll place before the authority. Authority will take decision.
That is already before the authority.
Yeah, that is their document.
And there is-
For this reason, my authority was called for hearing.
The writ court cannot intervene. Mr. Khan. Please understand. Because he has resided from his earlier stand.
But High Court has, I do not just he expressed because your lordship. I do not.
I am representing
that
my-
document has not been placed because there is no, because
Please
that
take
document is not with
instructions
me.
and come back. Please take instructions and come back. Please take instructions and come back.
And moreover, my lord,
The authority can have no role to play. if
No,
he
no,
doesn't
for
want
this
to.
reason, my lord, for this reason. No, may I say, my lord, transfer and transferee was called before the hearing. Transfer and my transfer.
You are
this is a writ court. This is not a suit for specific performance that you can going to force somebody to do it.
So I have disclosed why I could not appear in this matter. But he has not appeared. So, my lord, at least, my lord, he should place before the authority that this is the document.
And moreover,
That the authority, whatever that's why I will agree with that.
Authority has washed their hands off.
even your law does not authorize you to give the authorization in lieu of money.
As per statutory provisions, I was called because as per law, both if the joint application made, authority will consider the matter.
Nothing further remains to be adjudicated by the writ court. Because he has decided not to part with his vehicle.
Well, on this issue,
Why will the authority?
on the
take
authority will
comfort?
take decision because as per statute, we have called because joint application was made.
That part is over.
That was recorded before the authority. Now the another issue that now he want to withdraw these documents. So he will place that decision with the authority. No, that there is somebody I cannot take decision. Authority will not take decision. So
This happens to be an agreement. How can a writ court step into this?
Involved in this. It is an agreement between the
No,
parties.
why I am involved? Because already private respondent already made the representation before the authority.
That has been disposed of.
No, that has not been disposed of.
That has been, yes.
Rejected because none appears on behalf of the transfer and transfer.
Whatever it may be, it has been rejected.
Rejected.
So
What is because what is the language? Can you see the what is the language? Because
Mr. Khan, I'm sorry.
none appears for verification.
Reiteration will not help you.
None appears for verification. What is on the ground? None appears for
You have
verification.
submitted that.
This is a vacation.
The repetition will not really help your case.
Well, can you take after vacation? If one propose that is I will
Let him take it.
because that is the new issue. This is a new issue.
The private respondent intended to transfer the vehicle in question in favor of the petitioner, for which a joint application was made before the concerned authority. Before the respondent authorities on 23rd February 2023. Stop. Since the transferor and transferee did not appear before the authority on the date of hearing, the prayer was rejected by a resolution taken by the in the board meeting of the RTA on 27th March 2023. Stop. The petitioner prays for a direction upon the authority to revisit the issue upon hearing the petitioner and the private respondent. Paragraph, it is submitted on behalf of the private respondent that the private respondent does not intend to transfer the vehicle in favor of the petitioner and had entered into the agreement for transfer when he was not in a fit state of health. Paragraph, learned counsel for the petitioner seeks to take instructions in this regard. Paragraph, let the matter appear under the same affidavit of service. Let the matter appear under the same heading on 20th June 20.
My lord, liberty may be granted to submit the Vokalatnama. Department. As your lordship please.
Well, kindly direct me to solve the copy so that I can take instruction whether this has been proposed to the petitioner or not. Because he has taken the money.
I am not denying that.
Money agreement that I have any.
I am not denying that. I have made a submission before these honorable court. How out of blue I can hand over the.
Whatever money he has.
I record it. I record it. Okay, does not intend to part with position of name. Submitted on behalf of the private respondent. No. It is submitted on behalf of the private respondent. The private respondent has filed an application before the consent authority to this effect. On when did you file the application?
This application? My lord, it was filed on 27th March 2023.
27th March 2023, and undertakes to refund the money received from the petitioner for proposed transfer of the vehicle. Corporators, please take instructions. Yes, next.
20. What is this, your lordship?
198 is also same.
20, 20.
The next matter.
20 198.
Well, I am the petitioner, madam. On my application of a trade certificate not being accepted. Well, your law say I am made not accepted by the ATO. My respondent of 5. My lord, I have prayed for acceptance of the application with fees and to consider. My paragraph, let them consider, let them accept and consider. Page 12, paragraph D. Huh?
Under the rule 35 of Central Motor Police Rule.
Let them accept it with fees.
Form 16 for grant of.
Yes, madam. Well, I had to send through, well, your loss kind of page 54. As it was not being accepted, I had to send it through speed post without fees. But that is not the law. They have to accept the fees also. For that reason, I have to come before lordship with a prayer for acceptance of the application with fees and let them consider in accordance with the law. Huh? Associate dealer. It is decided by this court already. Hey, it is decided. Well, I have brought the judgment. Our court has decided this issue. Yes, he told to me.
Only dealer.
That has been accepted. My lord, this is money. It has decided the wrong judgment. Just mostly Bhattacharya.
Do you have the judgment?
Yes, my lord. But if your losses.
Please give him a copy.
They have decided, already decided.
That has been interpreted. Dealer means associate dealer also. Mala, kindly see the agreement. I have annexed. Kindly consider the agreement, madam. It has been decided by our court that
Please
this
show me the
associate
judgment.
dealer means dealer.
Please show me the judgment.
Well, I have not brought that judgment. I know you will take it tomorrow, my lord.
Not tomorrow, you have to come after.
After vacation, then, my lord. Well, I shall supply me document my land friend. I shall do it, man.
Let it be adjourned today, then come back after vacation.
Yes, yes, madam.
On prayer of the petition of the matter is adjourned, let the matter appear on the same. 12th June. Affidavit of service. Joint. 199.
199. In this matter, my lord, I am not the petitioner.
Subrata,
Yes.
and a motor vehicle boy down.
This is my affidavit of service.
This is send your appearance.
My lord.
Yes.
In this matter, what happened, my lord, the petitioner is a holder of a permanent stage carriage permit. And the petitioner made an application for timetable submitted along with proposed timetable. Thereafter, the respondent authority issued a timetable which is contrary to the proposed timetable. The petitioner moved before this Honorable High Court. Honorable High Court was pleased to dispose of the said petition by directing the authority concerned to consider the representation and issue a note. Kindly come to page 30.
Yes.
And thereafter issued a timetable. Page 31. Approve the timetable. Which is,
31, yes.
yes, my lord. Lord, here the authority approved the timetable, where from it appears that starting time 4:05 AM at top, my lord, from Karainagar Ghat. And the petitioner submitted timetable.
Senior ke bolla mama kata motor vehicle. Subrata boday.
That is at page 41. Page 41.
41 is the provisional timetable.
Rules.
Proposed timetable submitted by the petitioner.
Yes.
7:10 AM from Kanainagar Ghat. And the authority approved the timetable. That is at page 40. Page 40. Again, petitioner moved before this honorable court. Honorable court passed an order and thereafter issued a timetable on last timetable on 28th October 2022. Page 40. Kanainagar Ghat started at midnight. That is 4:15 AM. That is totally contrary to the proposed timetable submitted by the petitioner. Thereafter, the petitioner made a representation. Apart from that, what happened in the said route, 9 vehicles are plying. Out of 9, 8 vehicles are plying on the basis of rotational timetable. Though in the Motor Vehicles Act, there is no provision for rotational timetable. As per condition of the permit, the vehicle should be plied in accordance with the approved timetable. The petitioner thereafter, by stating entire facts, made a representation. They either approve the timetable submitted by the petitioner so that petitioner can able to ply her vehicle, or allow him to ply her vehicle on the basis of rotational like the other owners of the vehicle. That is still pending. That is at page 42.
Pending. Pending of what? Pending তো কিছু নেই।
না না এই রিপ্রেজেন্টেশন এইটা 22/3/2023 পেজ 42 42
এগুলো সব হয়ে গেছে, এগুলো কনসিডারেশন হয়ে গেছে।
Yes, Mr. Sen.
Now, my lord, so far, my lord, others are concerned. He says that total 9 operators are operating on the said route. Bearing him, the 8 have been granted rotational timetable. There is no dispute about this, and those 8 are not, my lord, they have no objection to that. They are plying their vehicle according to that. So whether that was legally or illegally, that is not to be decided in his writ petition. It is not his case also. So those 8, let them ply their vehicle according to their timetable, rotational or independent, individual, whatever it may be. What is his case, my lord? If your lordship kindly come to page number 33, this is the, my lord, foundation of his, my lord, case 33.
Yes.
My lord, on 6 September 2021, he made a representation. She made a representation that she, though was, my lord, favored with a permit, but no timetable was attached to that. So prayed for a specific timetable. May I read it just 1 or 2 sentences? Last paragraph. মহাশয়ের নিকট বিনীত প্রার্থনা, দয়া করে আমার দেওয়ার সময়সূচি অনুযায়ী একটি টাইম টেবিল শীঘ্র দিলে আমি খুব উপকৃত হইব। So he prayed for an independent, separate timetable, which was not in conformity with the rotational timetable. And he does not want to be included or inserted to that. Then, my lord, a writ petition was filed. And the order passed at page number 35, continued to page number 36, that the authority was directed to consider that particular representation with regard to his independent timetable. Now, in terms of this order, the authority, my lord, took a call. And my lord, kindly have a look, page number 39. Page number 39. Have you also got it, my lord?
Yes.
Memo number 274, dated 13 December 2022. Now, middle paragraph. Hence, an approved timetable is issued against the said vehicle against above noted permit PSTP number for smooth movement of the vehicle. Therefore, I, such and such, in exercise of power conferred upon me under section such and such, Rule 119 of the West Bengal Motor Vehicle Rule 89, is obligated to pass the following order. The annexed order. Timetable is the, my lord, annexed to that. My lord need not go to that. Whatever be the time. He prayed for a timetable. That was a proposed timetable. It cannot be that whatever he prayed, that should be granted. It cannot be. Because there are others also. Timetable should be adjusted in this way. And this timetable is, my lord, cannot be a fixed timetable. It may be adjusted again if somebody, my lord, other permit holder is allowed to ply his vehicle in future, then again. So this timetable was issued to him. Now he says that no, his representation at page 42, he is not satisfied with this. He said that timetable be allowed as per my proposed timetable. If your lordship kindly come to page number 43A, type copy annexed to that.
Yes.
It was not so legible. 43A, my lord, the
Last but, in view of above facts and circumstances, I therefore request you to kindly issue timetable by following proposed timetable dated 6 September 2021. That was the earlier main representation, in cancellation of the present timetable dated such and such, so that I am plying my vehicle smoothly or allow my vehicle to run the same on the basis of rotational timetable like the other vehicles. How can it be? His stand should be one, either an independent or rotational. If it is rotational, then my lord, the authority should take a call again. And the others, they should be, my lord, give a chance to, my lord, make their representation also. But all along he prayed, my lord, his individual timetable. Now, when individual timetable, my lord, after all it is decided, then lordship kindly have it to look, my lord, the rule 119. Once, my lord, rule 119.
Of the central rules.
No, West Bengal rules.
West Bengal.
Now, my lord, there should be a finality at least once.
Yes.
Rule 119, have a look, got it, my lord. In all cases of disputes in respect of timetable for stage carriage on a route or area, the decision of the transport authority granting the permit or of the other authorized, of the officer authorized under the rule shall be final. So it reached finality. Initially, he made an application for proposed timetable annexing to that. Whatever be the reason, my lord, that was not considered, then matter, my lord, came up before this court. This court directed the authority to take a decision. Authority has taken a decision that this is the timetable. He said, no, I am not satisfied with this. Now, my lord, kindly consider what would be the end of this. Because if your lordship remanded, then if, my lord, other timetable is granted, then he may say that if it does not match with his proposed timetable, he would not accept this.
He has given alternative proposals. He says either accept my proposed timetable or allow me to join the rotational timetable.
Then, my lord, rotational,
Bar.
then, my lord, let him take a final stand if that a rotational that I do not want. My proposed timetable, I do hereby withdraw, or I do not want that. Because all along, the authority, my lord, may I tell, authority proceeded with on the basis of his first representation, and that is the only proposed timetable, 6 September 2021, followed by that order of the Honorable Court. Now he says that, and that is not his fine, their stand is not the, my lord, the final stand. He said, either as per my proposed or rotational.
Alternative.
The alternative cannot be. If it is as per proposed, that, my lord, chapter is over.
Is there any bar, Mr. Sen?
With regard to,
Alternative prayers.
there is no bar, but he should
Let the
make,
authority consider. This court will not go into merits at all.
my lord, if this representation, my lord, goes to the authority, there would be some confusion. Because entire, my lord, representation, he says that my representation, it should be as per proposed. Bearing the last line, should let him make a fresh proposal, praying for that he also want to join in the rotational timetable already invoked on the route in question. Why alternative? Alternative, if that means that his earlier representation and the phrase both cannot, my lord, run on the same, my lord. So she kindly let him apply appraise before the authority, seeking that he want to join in that rotational timetable.
Mr. Sen, earlier representation is no longer there. It has been disposed of.
Yes, that is why I say.
Agreed. He
Yes.
has come up before.
Yes.
Now he is filing a fresh representation with alternative prayers. So let that be considered.
Well, it would be better if we make a fresh representation that I want to.
Necessary? I don't think so.
Very good, lordship. Kindly indicate this. My lord, kindly indicate this, that he now he want to join in the rotational timetable.
Yes.
there is, I
That
think
is
there would be no problem.
Yes,
Out of 9,
yes, there should
when-
not be any problem.
when 8, total 9 are in the fray, when 8 they are already included, why not 9? I think there will be no
Absolutely.
problem.
Affidavit of service. The petitioner is a holder of permanent stage carriage permit
I know.
and
বড্ড পুরনো মনে হয়।
applied before the concerned authority for issuance of timetable
ও
in his
এরা এখানে?
favor in terms of the proposed timetable submitted by him. Stop. The authority issued in disposing of the said application, comma, the authority issued a timetable which was not in consonance with the proposed timetable submitted by the petitioner, for which the petitioner approached this court
ও একদিন সকাল
in a writ
6টায়,
petition.
ও তারপর দিন একদিন আরেকজন, ও 6টা পেলো।
WPA 2230 of 2022. Stop. By an order passed on 7th March 2022,
বাইরে গিয়ে কিছু করতে
a coordinate bench of this court directed the Secretary, Regional Transport Authority, comma, Nodia, to consider and dispose of the representation made by the petitioner on 6th September 2021 within a stipulated time frame. Upon hearing all concerned, including the petitioner.
কি করবে সেক্রেটারি তো নদিয়া তো। এই 4 আর 5 তো একই লোক।
Upon consideration of the representation of the petitioner, comma, the concerned authority reiterated their previous stand. Authority reiterated its previous stand by issuing a timetable inconsistent with the proposed timetable submitted by the petitioner. Stop. The petitioner inconsistent with the proposed timetable submitted by the petitioner. The petitioner submitted a further representation before the concerned authority on
22nd March.
22nd March 2023 with alternative requests, colon dash, to issue timetable in his favor in tune with the proposed timetable submitted by him, or to allow him to fly his vehicle on the basis of the rotational timetable issued in favor of the 8 other operators of the route. Stop. The representation is yet to be considered by the authority. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents. Who should consider the secretary?
My lord,
The secretary should.
secretary. This one of 4.
That the 4th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 4th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order.
Well, only thing that while communicating my lord's order, a copy of the representation be annexed to that, because sometimes, my lord, it may not be available, then time unnecessary.
Upon affording reasonable opportunity of hearing to all the stakeholders including the petitioner, comma, in accordance with law. Paragraph, the petitioner is directed to provide a copy of the representation dated such and such to the authority at the time of hearing,
While communicating my lord's order, let him
Along with the order.
communicate along with,
along with the order
get,
disposed of.
এটা একটু দিয়ে দেবেন জুনিয়রের নামটা আছে।
In consonance, আলাদা আলাদা শব্দ থেকে stacked শব্দ।
200.
I'm depending on the other petitioner, only private is not private.
Yes.
Well, on the same issue, one is the last topic, I heard, say, well, I am holding a permanent contract as permit in respect of auto rickshaw. That is route number Ajipur to Mollar Gate, route number 184, page number 13. On a very small route, length of the route 20 kilometers, followed at least 100 vehicles are traveling. Now the Transport Department of West Bengal, pursuant to the direction of this honorable court, adopted a policy that is page number 90.
Page number?
Page number 90. This is the notification that was issued on 29 January 2010. And followed so many conditions here laid down for gun power rickshaw permit. And page number 22 relevant portion. Condition number 6.
Yes.
That the grant of three-wheel auto rickshaw permit within a particular district only may, however, be considered by the concerned RT of the district after taking into consideration the road condition, congestion of road traffic and security of the passengers traveling in such three-wheels. But the law has been liberal also to grant permit to any route. There is no bar. The right of the existing operator for grant to permit is very limited power to raise the objection. But Supreme Court held in one case, because of judgment in the last paragraph, 15. So far the other factors is concerned, before taking the decision for grant of permit, so other relevant factors, because road condition and other can be considered by the authority. So we made the representation, page number 23, is that involvement on behalf of the association. But here the individual operator has not been made. So kindly give me liberty.
They are not made in the.
The last year similar order was passed. Liberty has been given to the petitioner to submit the individual representation on this issue. Then authority will take consideration.
What is your prayer actually?
The prayer, my lord, to take decision on the basis. Mandamus prayer, my lord, page number 8.
So your prayer is to refrain from issuing other permits.
Consider that. Yes. But I made the representation.
How is your right infringed?
Yes, that I have already told you. Right of objection of the operator very limited under the new act. Because so far the other conditions concerned.
How is the writ maintainable?
That I have my representation has not been infringed. The right has not been infringed.
So how is the writ maintainable?
Because that there is no space for accommodation of the other. There is no space.
The authority will decide.
The authority for this I have the representation.
It is not your case that permits are being issued
No.
illegally.
So for this reason, what I made is disclosing everything, requesting authority to consider.
Withdraw, sir. Withdraw. It will be dismissed. You have no case. Yes.
But same matter was disposed of in the last occasion, right? Same matter. What is it?
Your allegation was that the authority is issuing permits without in violation of the notification. That is not your allegation here. In the earlier writ petitions, that was your allegation.
Allegation followed the root condition.
Here, that is not your allegation.
But this
You are asking for a direction upon the authority to consider the notification.
not yes, notification.
Writ petition doesn't like.
So give the liberty to make a fresh petition.
Nothing. Dismissed. Will you withdraw or I'll dismiss?
I'll keep it, madam, because my, this is one man, Julius Malor has requested me to appear. Go ahead, after advocation, because,
Let it be dismissed for non-prosecution.
was that my instruction for my junior, because it's a matter of junior, this is why, so he requested me to appear.
Come back on upon reopening. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 7 June. Two hundred one.
My lord, in this matter, my lord, I beg to appear for the petitioners, my lord. My lord, it relates to renewal of permit.
I sought to serve him. He has not.
My lord, he has got no, his right has not been infringed, my lord. My lord, it's concerning renewal of permit, my lord. How is he affected?
The right to apply before the court.
My lord.
Submit for addition of party.
You
My
receive it. You
Let there be
receive
a
it.
date for hearing of the application.
My lord,
Even in order to reject it, I have to hear it out, isn't it?
my lord.
So let there be a date. It is not in the file also. Did the
Wait,
application?
After vacation, may it appear.
Not in the list also. When did you file it, Mr. Shaw?
Like today it has been filed. For the first thing, it is appeared today. I applied for additional permit today itself.
No wonder it's not.
My lord, only to stall my permit, my lord. This is only to stall my permit, my lord. They are hand in glove. He's hand in glove with the respondents, my lord. The official respondents.
It has already been renewed today.
Then let it be recorded, my lord. I have no case.
I have raised my object without considering objections that cannot be done.
It has been done, my lord. Let it be recorded, my lord. I have got no case, my lord. I am grateful.
Maybe a separate cause of action.
Says it has already been.
But I objected to. That objection has not been decided.
Objection received by us, that has to be
Consider. বলো তুমি সেটা বলো তো আমি করে দেবো।
He is not yet a party.
No.
My lord, this is what is happening in the offices of the RTA.
These are raised by any of the parties that will be considered by the.
Mr. Debra, you say that it has been renewed already.
Renewed.
So now there is no question of
No,
receiving
yeah.
the objection of.
No.
When
Yes.
timetable is concerned, some operator made an objection.
I have against renewal even. I have raised objection against the renewal even. Kindly consider kindly consider my objection. Kindly consider.
Renewal has been done, my lord.
What I have said.
Sorry, you have no locus at the moment.
My lord,
You have no locus at the moment
regarding renewal.
regarding any.
Renewal.
Regarding submission before this court. In this.
No. Unless I am a party. Your logic, I'll take it up to day after tomorrow or after vacation.
Not possible.
Key, application tradition.
My lord, now that the permit has been renewed, my lord, my timetable should also be renewed, my lord. It was cancelled abruptly, my lord, without any reason, my lord. After extending it for 3 months, my lord, for consideration money. Because I did not get consideration money, they cancelled my timetable, my lord. This is my specific allegation in the petition, my lord. This is what is happening in the offices of the RTA and the BRLO.
Application come, let us deal with all the entire matter.
After vacation, yes.
That may be recorded, my lord.
That will be subject to the
Affidavit of
Service. Affidavit of service. The writ petitioner has. The writ petitioner has sought a direction upon the respondent authorities to renew his permit. Petitioners have sought a direction upon the respondent authorities to renew their permit as well as the timetable.
Dated 8/8/2022, my lord. 8th of August 2022. That is a timetable, my lord. 8th of August 2022, page 17. This was the.
See, my lord, after hearing the objection, that is criticized.
Paragraph, it is submitted on behalf of the respondents that the permit of the petitioner has already been renewed by the authority and the timetable shall be, and renewal of the timetable shall be considered. The timetable and renewal of the timetable shall be considered by the authority upon dealing with objections filed by some of the operators. Paragraph. You are one of the operators.
Yes, rival operator.
Paragraph, one of the operators seek to be impleaded as a party respondent in the writ petition. Paragraph, let the matter appear under the same heading. On 21st June,
Obliged, my lord. Much obliged.
Time to be written. The steps, your lordship kindly observe, steps taken in the, because they have filed and they have done today.
I'll hear everything you say after your application is allowed.
Grateful, my lord.
202.
Question, this is my application, my lord. I have served all.
Who is
This is
the
my
case?
affidavit of service, my lord. This is an extremely urgent matter, my lord.
I am appearing on behalf of the respondent authority in this matter, my lord. I have been instructed to appear. The copy has not yet been received. No instruction. Yesterday, they have served copy.
No, probably
My
my
client has-
48 hours before I have
My
served
client has
copy.
received yesterday only.
That is not the correct thing, my lord. My affidavit of service will speak for itself. Kindly see the date on 15th. It has been served.
Till
through-
time,
and
no
आपका बोलते
engagement.
नहीं? It has, petition has been served on 15th of this month.
It's an authority, Mr. Roy, not a private individual.
No, no,
who
my-
needs some time to take.
Lordship,
instructions.
may I say one
I
thing?
had
This
to
is
take
such a
instruction
matter, my
also.
lord. This is how they are resisting my prayer. All the respondents are here. They are instructing him to appear, but not giving him the copy so that the matter could not be taken up, my lord. This is an extremely urgent matter. May I demonstrate the urgency for 2 minutes, my lord? After that, lordship will decide.
What is your?
The urgency is this, my lord, the petitioner is the existing operator, is a license holder in respect of one parcel space in connection with Mumbai. He emerged as the highest bidder, contract for is executed with. Petitioner usually transports life-saving drugs, temperature-controlled life-saving drugs. I have stated in my writ petition, and also it will appear from the representation also. These life-saving drugs all comes from foreign countries through shipments. It enters the Mumbai port. From there, the containers are being taken to the railway yard. It has specific time period for transportation. We book those consignments, hoping that it will reach the Shalimar station at the specified time, which is stipulated in the agreement. Now, my lord, lordship is aware that these vaccines are all refrigerated in the parcel spaces, which has a minimum capacity of 48 hours. What the issue is this, my lord, the train is operating late for 10 to 15 hours every day. So the vaccines which requires to be distributed to all the nursing homes and hospitals in Calcutta coming from other foreign countries as per requisition, these are getting damaged. Under the agreement, there is a provision for placement of rakes at the stipulated period. Rakes are not being placed. This is the problem which has been acknowledged by the railways also. I will not trouble your lordship with any other document except their document. Lordship, kindly come.
If the railway is not in a position to deal with it,
Yes.
you say 10 hours, 11 hours delay.
Delay.
You have a time period of 48 hours.
Lordship, kindly come to railways later.
Maybe, even if it is accepted, you have a time period of 48 hours. So if
It is
the
not coming
train-
within 48 hours. What they are doing is, my lord, the train is running 15 hours late every day. This is what railways is also saying so. Now, the parcel van which is required to be loaded and to be distributed, these are not coming in time. The vaccines are getting damaged. Railway has stated that, yes, I acknowledge your issue and asking their department to rectify and resolve this. When railways are acknowledging and admitting that this is a serious issue, this is a serious problem, I am discharging a public duty and this needs to be resolved at the earliest, but they are not saying when. They are not saying when. That is the reason, my lord, I have approached, because every day I am paying fate. Every day I am entitled to the rake. I am loading the consignments. I am unable to unload. Neither I am allowed to take the rakes. So as per the railway is saying that hence it is here, page 113, lordship, kindly turns to once. I will not trouble your lordship for more than 2 minutes. Page 113. In reference to the above subject, it is to be intimated that this division has leased out parcel van LVH by train number to Mrs. Moonline Express Cargo Private Limited for the period of 2 years with contract value of such and such. And now the concerned leaseholder, by under their letter dated 10th of May 2023 has put forth their grievance, which is self-explanatory, and the same is briefed herewith. As per the concerned leaseholder, the train is usually running late by 8 to 10 hours in both direction, along with further delay by 8 to 10 hours during handling the VP at Shalimar, which leads to overall 24 hours delay, resulting the deterioration of the perishable consignments, including LSD, I have stated. Hence, it is hereby requested to look into this matter. If any such delay has been occurred due to operational reasons and within divisional control, then the same may be tried to be resolved at the earliest, as well as request for early placement of VP at Shalimar for unloading may be considered. In addition to that, if any grievance pertains to operational constraints found in their letter wide above, then same may also be considered to be resolved. This is railway saying. This is not I am saying.
Was issued on 12th May.
This was issued on 11th May. I have given a representation on 10th May, which is appeared at page 110, my lord.
And you've given that just 3 days time and you filed the writ petition.
Lashu, I don't have.
Very recent letter.
Lashu, kindly, this has a urgency, my lord. Every day losses are mounting, patients are suffering.
Take a call.
Railways take a call and let them say when they will going to sort it out this issue. Let them say that this will be sorted out within 24 hours or by tomorrow or within a week. Let their cutoff date may be fixed. My representation is there. They have acknowledged this is a problem which needs to be resolved. There are coordinate bench judgments, my lord. I am referring absolutely this aspect has been considered. Absolutely this aspect. Lordship, may I place the coordinate bench judgment? Only 2 paragraphs. Lordship, internal page 5, my lord. The pagination. Lordship has from the last paragraph, internal page 5, in the present case. In the present case, my lord, it starts from the last paragraph. In the present case, unfortunately, the railway authorities have not taken any steps towards resolving the issue raised by the petitioner in respect of unavailability of sufficient. There was the sufficient time was not provided. The operational no, my lord, kindly see the ratio of this judgment. Squarely applicable in respect for loading and other operational problems. It is incumbent upon the railway authorities to resolve the dispute immediately and to treat the period from the date when the petitioner raised this objection, that is May 29, till the date of resolution of the dispute as dice on. Insofar as the losses allegedly suffered by the railways is concerned, it is none but the railway authorities who are to blame for such losses, if any, since having acknowledged resumption of operation, giving a reasonable period to resume the petitioner. My lord,
The ratio is also not applicable.
may I say this? May I say this, my lord? I only
Come up with instructions.
Lordship, till such.
I would request you, till such, there is no interim order possible in this case.
No, Lordship, I'm saying this much. Only 2 lines I will add. That every day I'm paying, it is not possible for me to pay the freight charges at present because they are not giving me the rates as per the agreement. So if that be so, my lord, till they solve this issue, let them
Delay, that's all.
delay. And also I am losing money. My lord, I am only suggesting, my lord, let there be a prayer in terms of prayer G, which I have stated in the writ petition, that let them take a decision. Till such decision is taken, let them not take any coercive measure or let them not take any freight charge.
Coercive measure at all.
Coercive measure because, my lord, I am not in a position to pay the freight charges because of the reason I am losing my clients because I cannot give the LSD, life-saving drugs to the patients or to the customers. They are not giving the consignments to me because of their latches.
What do you say, sir? It's a serious issue.
I'm losing freight every day.
I have not yet received the brief. I have to take
Lordship,
instruction in this matter.
this is the Calcutta I have given 48 hours back. They have engaged the lawyer, but they have not given the brief. Lordship, this is serious issue, Lordship. Kindly protect me for at least 14 days. 14 days, Lordship, kindly protect me. Let it the matter kept on 5th on reopening. Lordship, let the
primarily seeking financial protection, sir. You're not nothing.
Lordship, let them, because why I'm saying so, my lord, they have acknowledged this issue. Let them resolve it within 7 days.
Come back immediately after vacation with instruction.
Lordship, within 7 days, my lord, let them sort it out. Till that date, no coercive action will be taken. Only to that extent.
Coercive action. there's
Because,
no
Lordship,
question
I
on the coercive action.
because, my lord, I am not in a position.
Concerned with the patients or the drug.
I am concerned with,
money.
I am concerned with the patients, my lord. At the same time, my lord, kindly appreciate my lord.
Make your submission for coercive action, otherwise.
No, coercive action because of this reason in the policy. My lord, kindly 1 minute, only 1 minute. My lord,
He's not in a position. Why do I spend more
no,
time? on this?
let then be on Friday, my lord, this Friday.
Within a short period, my lord, it is not.
I know they will say so to defeat my in prayer for interim order, my lord.
Serves. Learned counsel for the respondents seeks to take instructions in this matter. We are reopening on 5th, let it be on 6th.
Lordship, till such day, Lordship, no coercive action. Lordship, I am not in a position to operate, my lord. I want to suspend this operation because of the reason, my lord, I'm not getting my consignments. And they have acknowledged this issue, my lord. It is not that I am saying, they have acknowledged it.
No order can be passed without hearing the railway.
Lordship, then my representation may be considered, and till such consideration, no coercive action may be taken.
That second part will not be considered at all. There is no question of any coercive action.
Lordship, only one thing, my lord, as per the agreement, if I do
The
not,
matter appear under the same heading on 6th June.
Lordship, only one thing, my lord. I'm saying so because under the agreement, if I cannot pay, because consignments are not being given to me, from there I get the freight.
Sir, given to you at a delay, sir. It's not that it's not being given to you.
No, I am not being provided because kindly see the last page. Last page of the annexure is also from the railways communication.
Documents on the next day.
No, Lordship, only one thing, my lord. If I suspend my operation from tomorrow, I have given a notice to them. I have given a notice to them that let it be treated as a notice of suspension. Then at least no steps may be taken to terminate my contract till that 5th. Till 5th, my lord, it is only 1 month of only I have operated. 2 years is still there. Contract is a high valued contract, my lord. 25 crores is at stake. Lordship, only 15 days time.
When are you suffering this problem, sir?
Suffering, I am suffering it for 15 days. I have only started operating since 1 month only, out of 2 years of contract. 1 and 9 months of.
File the application just a couple of days before the vacation.
Because of the railways action, I am suffering. I am communicating. I am going to their office. They are not giving me any protection, my lord.
In the meantime, please see that necessary.
Let there be an assurance from the bar. At least no coercive action will be taken. Let there be an assurance from the bar.
I'm not recording any order because you don't have instructions. Let there be no coercive action and please try and resolve this issue.
Only this thing, my lord. Let it be done within 1 week.
Drugs which need to be taken care of. Yes.
Assurance, this assurance is.
To him. I hope
He has assured in the bar that no coercive action will be taken, my lord. Because ultimately, my lord, if I continue with the business,
the matter immediately upon reopening, come back.
they will be benefited.
Instructions by them. And I hope the problem will be resolved by them because we have 2 weeks in between.
Lordship, in the meantime, Lordship, if you recorded, my lord, no coercive action may be taken.
Without instructions, I cannot.
In that case, I will assure them that they will not take.
Without, yes, it's from the bar.
From the bar.
Grateful to your lordship.
Grateful, my lord.